Lordship, I beg to mention item number 3, Lordship. Here, Lordship, learned age is appearing for the estate, Lordship. He has some difficulties, Lordship. He has requested if it can be fixed on 22nd of next month, that's July, Lordship.
Okay, let the matter reach, will pass the order.
Lordship.
Your Honor, regarding this case, I have objection. There are so much of the adjournment, Your Honor.
Which item?
Item number 3, Your Honor.
Let the matter reach. We have not passed any order.
Item number 1.
May it please, Lordship. Miller, this PI
Yes,
which
Mr.
we are
Das.
seeking, yes, Miller, in
Just
this,
a minute, just a minute. Mr. Das, just a minute. Mr. Das, service report on the respondent numbers 11, 12, and 14 to 20,
Yes, Lord.
not yet complete.
Okay.
So,
My lord, only our case is that on the last occasion, your lordship had ordered for
we have
a.
seen, we'll come to that, but thing is this, before proceeding that,
Yes, yes.
probably, since the report hasn't come yet regarding
Yes.
service of notice on those
Yes.
respondents,
We took steps
Ah.
on the second occasion.
we have seen on 2 occasions you have taken steps. But the best way is to publication of the service of notice through the paper publication and
Yes.
nothing else.
Yes.
Okay, now, respond number 10, my lord. Status. My lord, I am. Take your seat. We'll come back to you. We will. Cut it. We have a knife. Give it to brother. Give it to us. Give it to brother. Give it to brother. Brother, take a look at it. Okay. I'll look at it. Mr. Das, your claim is with regard to which villages?
My lord, I have given specific instances with document at paragraph 7 of my PIL. It relates to the Upper Siang district.
Can you tell the name, at least name the villages?
My lord, only the problem is that, my lord, if your lordship takes up the my representation to the chief secretary.
Page number, please.
Yes, sir. At there I have detailed it at page 73. My lord, the problem arose because this when we came on the last 3 years prior to today, they did some investigation, but the reports never came. And it is at that stage we went to the chief secretary. And
It's okay, but your complaint is with regard to which villages?
My lord, it is a lordship will find at page. My lord, I have given the executive engineer's detail, the division. My lord, the villages, my lord, it is that I could not get. I'll give it, my lord, on the next date where they fall. Lordship will find at page 74, Public Works Department, the division I have stated, Yungkong division, and I have named the officers also with documents. Well, it's a very serious case of squandering of public money, and the larger public interest is involved because these officers gave the contractors enlistment was done subsequent to the works being done. And minors were also given contract, well, unheard of. In fact, in order to instill the confidence and credibility to the system, we wanted an independent inquiry, court inquiry. In fact, if the respondent 10 at least gives an affidavit to the effect, what is the progress, we can come to know which cases they are taking up, because our complaint is to the chief secretary. To our knowledge, they have not done anything on the chief secretary's complaint. In fact, we have approached the Constitutional Court because we don't have faith in the administrative mechanism. Well, basically, it is in the village Yingkong village.
Mr. Das, how the petitioner collected this information?
My lord,
How
we,
the petitioner collected the
my lord,
information
through,
with regard to the allegations made?
yes, my lord, this, we got it through RTI, and some documents we have said we were not furnished. And from 2022, we were pursuing this matter.
Who is the petitioner?
Well, petitioner is Mr. Empalo Mina. He's a social activist who has on earlier occasion also had been to this court filing PL. Well, he takes up these issues of public issues of corruption in places.
If after the inquiry, the allegation made by the petitioner comes out to be a zero, there is no such allegations to be proved, then what will happen?
Well, not,
If after the inquiry is complete and it is found that the allegations are false, what will happen?
well, not from the documents.
Petitioner will face the consequences.
Naturally,
He is ready to face the consequences, Mr. Das.
If the documents given prove that it is false, naturally he will have to face.
Have the information, have the instruction from the petition. Because he is taking judicial time of the court. So also the time of the investigating authority before ascertaining whether these things had happened or not during that particular period. But anyway, as on date, we are not saying anything on this regard. But the petitioner has to face the consequences. Ask him in that regard, get the instruction and tell us.
Yes.
Mr. Ratan, take your seat. It's fine. Yes.
Yes, Mr. Ratan, you wanted to say something?
My lord, I'll just take your lordship to paragraph 10, my lord, of the PL. It's in page 23.
Yes.
May I read, my lord? The petitioner thereafter filed WPC number 226 of 2023, highlighting the modus through which the respondents aided and abetted in siphoning of funds meant for development without works, even doing any work at ground level. But the Honorable Court, by order dated 16/5/2023, observed that the remedy lies in the criminal law and accordingly disposed of the matter. The petitioner thereafter supplied further information to the officer in charge of SIC Vigilance and finally filed a representative dated so and so. My lord, that order, my lord, has not been annexed, but of 226, my lord.
Okay.
With regard to the same matter, earlier the petitioner has approached by way of a writ petition under 226, my lord. I'll read from the second paragraph, my lord. The law is well settled by the Honorable Supreme Court in the case of Sakiri Vasu versus State of UP, reported in so and so, wherein it has been laid down that the matters pertaining to non-registration of FIR or delay in investigation are not to be entertained by the writ court, as remedies lies in the criminal court of law itself. This court is also of the opinion that in exceptional circumstances, the power of judicial review would still be available. The present case does not appear to be.
Mr. Ratan, that was a writ petition.
Yes, my lord.
Now,
This is
a
also a PIL under 226, my lord.
Doesn't matter. And matter relates to influx of fund, public fund. And that is why the court,
My lord,
there is a difference between the writ petition and a PIL, as you know. And that's why the division bench earlier issued notice.
My lord will kindly
Correct.
see the complaint. It is not siphoning of fund. It is issuance of fake certificates, ma'am.
Fake certificate allowing that work. Let the report come. Finally, we'll see to that. You are appearing for respondent number?
My lord, I'll be appearing for respondent number 125, my lord. 129. Oh.
We are objecting. You should welcome.
Yes, I'm not objecting, but because this fact, although stated, they have, because they have withdrawn the repetition itself to a proper
petition because there was a by the judgment of the Sakiri Vasu, there is a clear observation that the petition is not maintainable. Why? Because there are certain provisions which needs to be followed by a particular complainant before approaching a writ court with regard to any such criminal activities. That is the Sakiri Vasu, right? So anyway, we're not on that. Mr. Das, for
Yes.
the time being, with regard to the service of notice on the respondent numbers 11, 12, and 14 to 20, let the petitioner take steps by paper publication
Yes.
to be published in the two widely circulated newspapers in the
English.
state of Arunachal Pradesh and in the Upper Siang district. We have perused the up-to-date status. There are certain materials. Let the investigating officer given some more time to place the up-to-date status.
My lord. My lord, I'm appearing for respondent 14.
Good. You are appearing for respondent number 14.
Yes, my lord.
So service on respondent number 14 is complete.
What's your good name? What's your good name?
Oh, morning.
When did you file a Kalatnama?
Yes, ma'am, this morning.
So you have filed a power. You are appearing for response number 11. What's your good name? Just record the names. Anyone appearing for other respondents?
3 and 8.
You are appearing for?
3 and 8.
I'm appearing for respondent number 13.
You are appearing for response number 13. None for 12, right? So 11 is complete, 14 is complete, 13 already appeared. 14, 13 appeared. Pursuant to the earlier order, dated 18/06/2024, Mr.
Oh, Pada, madam.
O. Padar, and its standing counsel for the SP SIC within bracket Vigilance Itanagar submitted the investigating up-to-date investigating reports with regard to SIC within bracket VIG, IG small, PS, discrete enquiry numbers 072023 and 082023 involved in this PIL. We have perused the same, place the same in seal cover. We have perused the same. As such and such appears on behalf of the respondent number 11 and 14. Service of notice on those two. Service of notice of this PIL is complete on those two respondent.
11, 15 or 13.
Peruse the office notes dated 20/06/2024. Service report on respondent numbers 12 and 15 to 20. Are yet to be complete. On 2 occasions, the petitioner took steps on those respondents as directed by the court. Considering the above, the petitioner is directed to take steps on the respondent numbers 12 and 15 to 20 by newspaper publication. Full stop. Such steps on the respondent numbers for 12 and 15 to 20 shall be made by the petitioner to the registry of this court, publishing the same in 2 local dailies widely circulated in English, widely circulated in the state of Arunachal Pradesh and Upper Siang district. Such paper publication shall be made by the petitioner to the registry of this court on or before 5th of July. Thereafter, petitioner shall post of the file an affidavit in this matter, along with the copies of those two newspapers, wherein such notice been issued to the respondent numbers 12 and 15 to 20. List on.
Can it be, Lordship, a little accommodation on the 22nd? Some matters are fixed.
July.
Yes.
No, we are willing to give some more time to the investigating officer.
Okay.
So we'll fix it sometimes in August. We'll fix it on 22nd of August. Will that do, Mr. Das?
Yes.
22nd of August.
22nd.
List on 22nd of August. On the said date. The respondent number 10 shall submit before the court the up-to-date investigating reports with regard to those two already vigilance discrete inquiry in seal cover. Yes,
Yes, only one thing I want to add. Well, the discrete inquiry, insofar as the Chief Secretary's complaint, there are 7 officers where we have given specific documentary evidence. The inquiry should also include them, because till now
it is with regard to them. As of now, we are not saying passing any order with regard to the. Let the inquiry officer complete the discrete inquiry, then we'll see. But we'll not give further time.
Yes, sir.
So that is why we're giving 2 months time.
Because this I want to say, because now the Supreme Court has said that the power of investigation and reinvestigation is only with the Constitutional Court. That they have expanded the scope of the High Court under 226. I'll place the decision on the next date.
Okay. Less on 22nd of August. And the said date. In the meanwhile, the respondents shall file their affidavits, if any, serving copies of the same on the counsel for the petitioners. Yes, names of the counsel for the respondents so far appeared shall be reflected in the cause list for the petitioner as well as the respondents. The up-to-date status report placed before the court by Mr. Potter, standing counsel for the respondent number 10. Retrial.
Obliged, madam.
Obliged. They return them in the seal cover. Yes, Mr. Tara.
Well, this is appeal against acquittal against the impugned order dated 9/9/2022 passed by learned session judge West Command District Bombilla in session case number 9/2020. My argument, my lord, would broadly based on 2 counts, my lord. The first would be
Let us go to the trial for judgment first.
No, just outlining, just on 2. Then I'll come to the judgment. Normally,
you are relying on certain issues,
yes,
right?
Yes.
Because
the first is on the patent procedural error committed by the learned court below. At the
Say that-
time of,
Don't say code below. All has a hierarchy, right? Say it as a trial code.
okay. Well, my lord, this has been a habit for
Yeah, I
long.
mean, that's now you so see, we are also code below in the Supreme Court, right?
Correct.
So every court has its own status. It is better to say the trial code.
That
or a
is
magistrate's court, not-
great eloquency in the thing, my lord.
Yes.
So, my
Yes,
lord,
yes.
Yeah.
Yes.
Then secondly, my lord, even the
Notice have been duly served.
sir, even the ocular evidence
Hmm.
and the direct evidence are in my favor. Because there are clinching evidence that shows to an extent in 313 statement, my lord,
Hmm.
the accused have admitted the guilt. Then that's that apart, the learned,
313 statement
I'll come.
made by the accused have admitted the guilt. While recording 313 statements in the CRPC,
That,
whether can we acted upon?
no,
Even
that-
if it is says so that yes,
but
the
that will
accused
have a,
commissions have committed the
no,
crime.
my lord, that will have a bearing of
How
evidence.
come?
That
While
will have a
making
bearing.
313 statement by the accused or while recording the CRPC.
Bearing to the evidence for corroborations of an
where-
offense committed.
whether the accused sworns,
Correct. my lord.
what value it has when it is not, it is only the 313 is a statement where it's a kind of natural
No,
justice.
that is, no, my lord is trying to,
That is why there are judgments of the
No, no,
apex
no.
court, our high court, that
Yes,
if somebody
no,
is
that-
saying that, yes, I have committed the crime in 313, that
I'm-
cannot be
I'm-
acted upon.
my lord, I am aware of that. That's why my lord is trying to pull my leg on the objective of 161. That is not substantive
of all-
piece of evidence.
First of all,
But
whether
these are
there
all corroborations, my lord.
No, whether there are sufficient material evidence during the trial brought by the prosecution against
Correct,
the
correct.
accused, and whether those are beyond reasonable doubts or not.
Correct,
To that
correct.
extent.
Now, my lord, we'll kindly come to page 40.
40.
Here.
No, what is the reason for filing this appeal against acquittal?
Well,
You are
two-
aggrieved by certain reasons.
Yes,
right?
that's why.
Okay.
The-
First finding that what you are saying that there are sufficient ocular evidence.
Ocular.
Okay.
Secondly, my lord, patent procedural error committed by the learned court, trial courts, my lord. First, my lord, what had happened was, both of them separately went to the jungle by a mistaken identity
he shot.
because of saw death. Then he comes to the police station, inform the police, saying that by mistaken identity, I have sought that the person. And then his statement was recorded by the police and reduced to the FIR. Then he was asked to lead to the place of occurrence where the gun was seized.
He was asked or he led?
He led.
He
led.
himself led or it was
He
asked?
himself led. The IO along with the IO.
Is there any disclosure statement?
It is there.
It is there.
There. Then gun was recovered, the weapon
From the place of occurrence?
from the place of occurrence. And then the FSL, everything, it corroborates that was usable and that it has a potential of killing a person. That is the FSL report. Then what had happened? The charge sheet was laid before the learned chief judicial magistrate under section 302, read with 25 and 27 of the Arms Act. Now, the requirement of the law is that there must be a previous sanctions. That previous sanction under the Arms Act falls within the parameter of section 39 of the Arms Act. And without the previous sanction, you cannot institute a criminal proceedings. That's the first mistake, a technical mistake. So then, since thereafter, without invoking 209, the learned chief judicial magistrate makes a
Committed the
committal,
matter to the trial.
makes a committal to the session court because the section 302 was exclusively triable by the session court. Then one head charge was framed. Pertinently, my lord, the learned district and session judge have dropped section 25 and 27 of the Arms Act, and charge was framed under section 302. That is the exact situation in this case on the procedural part. So before committal, my lord, and compliance of section 207 and 8 of the CRPC, the learned Chief Judicial Magistrate at the first instance ought to have directed the investigating officer, please obtain previous sanction for prosecution under section 39 of the Arms Act. This was not done.
What is the reason for dropping of section 25 and 27?
No
of the Arms
reasons. There was an objection from the public prosecutor also. In spite of that, this was not done.
Whether the arms was licensed one,
Yes, Lord.
where?
It
License
was,
proof
it
that
was,
he had a
it was
license?
licensed one, but someone else.
No, whether the,
SSB board.
whether the license was
License.
seized. Whether the license was seized.
Yes, yes, my lord. And it was further
It-
in
is it
the
there?
order.
Is it there?
It is there. It is recorded. It is also recorded that the gun license should be cancelled.
It was in the name of the accused or it was in the name of someone?
Can we just see once where the gun license?
My lord, normally it will always be annexed in the last page of the
Okay. Let
order.
us see in the paper book.
Yes.
It has to be there.
Oh. My lord will kindly come to page 50 straight.
40.
50 of the paper book. Para 30. It says 30 is the acquittal. 31 says it is ordered that armed license issue in the name of Singyum Gadi. I think he was having a gun license. Is the accused. Be cancelled immediately and the SBBL gun used for hunting be confiscated. Let a copy of this judgment so and so. Seize 12-bore SBBL gun bearing number 69619-1996 is confiscated and the same be sent to the district magistrate Sapa for disposal as and when the same is received from the CFSL Kolkata.
No, this is only gun number.
Yes, gun number license.
Where is the license and license number? License in the name of
No,
And
the
the
pair
seizure-
31.
list of the
Yes.
list of the exhibit.
No, it may be in the seizure report. Where is the seizure report?
The seizure will be here at page
Seizure memo 11.
11.
11. Yeah. Let us see at 11.
Below mentioned articles so and so.
No, the license has not been seized.
License have not been seized. Particular of seizures, one SBBL gun. Bearing number is same one, but the
No,
license.
that is gun number only.
Gun number,
I'm asking about the license. Whether
License.
the gun seized or purported to have used for commission of the offense
Correct.
had a license, or if there was a license, in whose name?
In para 31, para 31 of that acquittal order, it appears it is in the name of
No.
The-
Where is the license? On assumption, it can't be.
correct. I'm not disputing, Mala.
Hmm.
What I'm trying to refer is in terms of the paragraph 31 of the acquittal.
What I'm saying
Yes,
is if the gun was not a licensed one,
correct.
if he did not use the licensed gun, probably the prosecution sanction may not be required.
But that has to be reflected in the order.
Not
That has not
reflected.
been dealt with by the trial court. No, my lord, for brevity, can we straight to proceed to page 40 and 51? It's 11th page we read and then we go. I'll exhibit the evidences, my lord.
Page
50 on those. No, sorry, not 51. It comes from page 40 minute. Here one, page 41. If their lordships have got it, I can proceed. Licensing. From where he is. Well, can we start?
Just a minute.
Yes. After the form 1A. NPS reports, seizure, currency report, arrest and I have to record confess the recording of this.
Have you annexed the order by which the Lionel Trial Court, the Session Court has dropped
It's there. That's
the offense under this one, Arms Act?
It is not there, my lord. It will be from the records, page 9.
So this is charged under one head only.
Yes.
May it please, Your Lordship. Lordship, the charge of arms under Arms Act was dropped during the framing of charge, Your Lordship. Because criminal trial was only on section 302.
By saying what it was dropped. That
Yes,
it was
yes. During the framing of charge.
Framing of the charge.
For want of prosecution sanction.
For want of prosecution.
Is it there?
Yes.
The order?
It's order.
this LCR.
LCR, Your
LCR.
Lordship.
Like these documents were not given to us, right? So then, my lord, he or the Lionel Trial Court ought not to have proceeded with the trial because the procedure was not fulfilled. Still, that is good. Oh my, gun license to यही है. Number यही, gun license to.
Now, if Your Lordship will also come to page number 9, Your Lordship, of the paper book. Page number 9 of the paper book, Your Lordship. Your Lordship.
What is there in?
Not in the paper book, Your Lordship.
paper
Not,
book?
yes,
Charge with one.
not in the record,
Hmm.
paper book.
Yes.
Page number 9, Your Lordship, the
Yes,
charge,
yes,
and therefore the criminal trial proceeded under only one charge, that is 302,
yes,
Your Lordship.
gun probably was not proved that the gun belongs to the accused.
Pardon, Your Lordship.
It was not proved. It was not shown that the gun belonged to the accused
Yes,
and the gun had a license.
yes.
There wasn't.
There was no license with regard to that particular gun, and the statement of the IO clearly states, and therefore he did not send for prosecution sanction. There was no prayer made for prosecution sanction.
No, no. That's it for the photo.
Not,
Yes.
if Your Lordship will come to the statement of the IO, Your Lordship, at page number 30.
So we need here.
It appears that the trial court has observed in para 28. Can you just see?
Yes, Your Lordship.
Sunungyari is holder of the arm license.
Yes,
But an arm license, he was a holder of the arm license, having all numbers. It was
There-
never proved. How could he come into such conclusion?
yes, Your Lordship. In fact, we are also not, the conclusion came by the Honorable Court is,
And then license.
there is no, there, if Your Lordship will come to page number 30, Your Lordship,
Hmm.
the IO who had seized the gun, Your Lordship.
38.
30, Your Lordship.
30.
30.
Also pera, Jasmine.
Yes.
Jasmine.
Your Lordship, the relevant paragraph
Criminology.
is at page number 31.
Hmm.
The seventh line of the page, Your Lordship, which
Yes.
starts from, I also made true inquiry on arm license of the accused, but he does not have any license.
See,
And then the next page, Your Lordship, at page number 32. The fourth line, Your Lordship, it starts with, the accused failed to provide any license during investigation. So I do not feel it obtained.
this is the
Will it-
position.
This is the deposition of the
Of the
IO. Yes, Your Lordship.
Okay.
Now, on what basis the Honorable Court, while acquitting the accused, has stated that the accused is a holder of a gun license, arm license, Your Lordship.
And in the judgment also, arm license issued in the name of so and so be cancelled. So without mentioning the name.
That means there was a mens rea instant with an intention to kill
No,
the
no,
person.
mens rea may not be there because he himself has, after that, mens rea may not be there. But instead of 302, 304, part 1 could have been.
Correct.
Hmm.
That is what learned PP also have made the objection at the time of framing charges. Page 88 of my page 87 of my appeal.
Hmm.
तो उसको वेरीफाई करना उसका ड्यूटी था. Yeah,
No. Yes, madam, can you tell us any of the witnesses accepting the IO
Yes.
statement that the accused didn't have any such gun license? Whether any such accused, any prosecution witnesses place it before the court that the accused had his gun license?
No, Your Lordship. There is no, in the entire deposition of other witnesses, Your Lordship, none of them has stated if the gun was licensed or not in the name of the accused, Your Lordship. The IO who had seized the license gun, Your Lordship, he on inquiry has revealed that the accused could not
No,
produce
that is,
any license.
quite disturbing where from the trial court came to the finding. That
Yes.
he has a license.
Yes, Your Lordship. Even if the situation would have been different if the accused was his own defense witness and has
See,
provided.
what brother is pointing out to the court or to the you as well as others, that if there is no gun license,
Yes,
assuming there is no gun license,
yes,
then question of dropping section 25 and 27 arms acts will not count.
yes,
It is amount to illegal occupation of the
yes,
gun
yes.
or the arms and operations. So definitely.
Which for
The only ground for dropping section 25 and 27 of Arms Act was that there was no prosecution sanction, which is mandatory. Lord. But as far as I'm aware, Your Lordship, 25 prosecution sanction is mandatory, Your Lordship. But regard to section 27, there is no prosecution
if there is no license,
of
not
prosecution sanction.
so you represent accused,
Yes, legal aid counsel for
legal
the
aid counsel.
accused, respondent to.
Going against it appears. Anything.
In any case, since there was no prosecution sanction, and since the court has framed the charges under 302 and the trial proceeded, arguing that prosecution sanction should have or should not have been given, or the trial should have been stopped, or whatever my learned friend is stating, is of no significance. It is, in fact, I would say, counterproductive, because this is an appeal against acquittal, not against conviction. This would, in fact, favor the accused if such a statement is made.
Bad. Ask the library people to have this. There are two volumes, one and two, in criminal minorities. That will have all the facts, excepting the PCCRBC or the evidence, all the criminal acts will be done. So three volumes, are there one Say something good for the reference, because otherwise if you find all the that you have all the ends, all the criminal matters. Okay, yes.
Unless he has been specially authorized. Section 7. Mr. Tara,
Mileage.
do you have any power to show us that no prosecution sanction is required or necessary for using the unlicensed gun?
Using unlicensed guns to kill somebody, it will come under unlawful act only. Because there is no judgment on that, Milad. I just made a search on this. Unauthorizedly using someone's gun and to kill, that is illegal possession of the arms.
you say that the accused led to recovery of the
Correct.
gun.
Correct.
Where do we find?
Well, can you come to page 7?
Yes.
During my course of investigation, it came to light the incident had happened on 27/3/17, and that body was already buried on next day. My party was willing to lodge FIR. No party was was willing to lodge FIR. The matter was brought to notice of police by the accused, who came to surrender. The alleged accused was arrested on 4. He was remanded into police custody for a period of 14 days after two productions before the Honorable Court of CJN. He was thoroughly interrogated during this period. The weapon of offense was located and seized. A prayer was made to district magistrate and district medical officer to detail a magistrate and medical officer to examine and post-mortem examination dead body, which was accepted. Accordingly, on 10/4, two magistrate, Takam Nicholas, Dr. Police team to Sarawak, the dead body was examined in the presence of the magistrate, doctor, relatives of the deceased assemblies. The post-mortem, so and so, one thing. Course of this during course of investigation, the weapon of offense was sent to Central Forensic Laboratory, Calcutta, for the alleged accused failed to produce any documents, license to claim ownership over the weapon. He stated that the person of Puroi had stolen his license, but failed to give the name and address. The arms register maintained Deputy Commissioner was checked, but no arm was found issued against him.
No arms were issued.
No, yes. Well, that means section 25(1)(a) will come. 7-year punishment is there if somebody has illegal possession of the arms.
And probably it was also recovered on being led by some other two witnesses, not by the accused himself. Accused disclosed it to somebody, two
Which
witnesses. The weapons. Come to 45. Page 45.
25 to 5.
Last 6th. The weapon of offense was, kindly read that.
Page 45.
45.
Okay.
Counting from the last 6th, the weapon of.
Paragraph, Milord?
From the last, okay, count upward, 6th.
1, 2, 3,
The weapon.
4, 5, 6. Okay. The weapon of offense was recovered from jungle on disclosure of accused of 2 of the locality of that area.
Disclosure of accused to 2.
Yes.
Of the locality of that area.
Correctly. Accordingly, on lead of Mr. So-and-so, the weapon of offense of one assembly gun was recovered. Because, Milord, all the
not by the accused.
No, Milord, what I have here is, he has disclosed, after committing the crime, he has disclosed to all the prosecution witnesses. It is there in the statement of the prosecution witnesses. After he sent so-and-so obtained for opportunity to use for filing. He has charge sheeted under section 30 so-and-so. As per his finding, he did not agree with the statement claiming that he saw the deceased mistakenly. Accordingly, as he saw the torchlight of the incident.
So at the time of filing charge sheet, because it was under the assumption that prosecution sanction was necessary, whether the IO kept open for filing supplementary charge sheet under 173(8).
No.
Let us see in the last part of the,
they
have kept open.
Yes, nothing, my lord. He has kept nothing. In the light of our facts of prima facie, lay with me. Page 8 kindly come. Therefore, I am submitting this case into charge sheet so and so, number so and so, under section so and so. The Honorable Court is prayed to fix a date for trial. The witness mentioned in column 13 may be summoned. He has not kept anything open. That would also a fatality in the procedure itself. Normally, Miller, I think 173(8), they used to make the trial. Correct. 173.
In the 313 also probably he has nowhere stated that he had a gun license.
Yes.
Has he stated? No.
Yes, Miller. That is 281 is for 313 state. It's 23 to 25, my lord must be ready. Now the page 23, my lord, can come back, page 23. Question number 1, in the answer he says,
Yes, but
it is a fact that Kak died due to the bullet injury fired by me during the time of hunting, but I have not killed him intentionally. After the incident, I have disclosed about the same to PW1, 2, and 7. Then, my lord, kindly see question number 2, my lord. Srimat PW2 so and so deposed that on the date of incident, she went with you for collecting wild potatoes. Thereafter, you went to jungle with a gun for hunting. Later on, you came back and disclosed her that you had mistakenly killed the deceased in jungle. What do you have to say? I went to jungle for hunting, but I do not know Kak was also went for hunting. Now, question 6 at page 24. PW5. Dr. S.N. Pandey has examined the SBBL gun and reported that the same is a firearms and enough to kill a person at close range. What do you say? It is a fact. 7, Milord, is important. PW7, Neka Gyadi reports that on the evening of incident, you went to his residence and told him that you have killed Kak Tana, mistaken him as wild animal. You led him to the PO. You led, it should be led, Milord. You led him to the PO. On his arrival, deceased was alive but not able to speak. He has seen the injury mark and this is come to injury. What do you say? It is a fact. So, Milord, that conduct, what has been defined in the section 8 of Evidence Act, obviously comes, is nothing but admission of the guilt by means of confession. कौन सा वाला में My lord, here in the paper book, a 161 statement is not there, but in page 64 of my appeal, my lord. Their 161 statement, he has clearly admitted also. Almost that is only for corroboration, may not be a substantive piece of evidence. Page 65, 64, my lord will come. My 65, that page 65, my lord, yes. Yes. Then I inform you. My lord will come to page 64, 3 lines from the bottom. Then I informed Srimati Yarotana, the wife of late Kaktana. Later, the whole blaze came to know of it. I took along Sri Mekha Gyadi, who is my distant brother, and showed him the place where I sought late Kaktana. After showing him the place, I escaped and fled from the blaze. I fled from the blaze fearing for my life because of the prevalent revenge system. I escaped with my gun, a mobile set, and my dhow machete. I stayed in jungle for 4 to 5 days, during which I ate wild tubers and rhizomes. I realized that my life was at risk, so I decided to surrender myself to police. Prior to this, I maintained no enmity with so-and-so, as he was my brother-in-law. My wife is his elder sister, though I often quarrel with my wife. I never dislike him. The gun, my lord, that is important. The gun which I used is mine, but the license is stolen by someone. I have hidden the gun in a jungle near Puch River, which was recovered.
This is 161.
Yes, 161. Yes, keep on. Now that apart, my lord, will see the section 27 of evidence act. Then broadly, it would be clear. I know.
Mr. Tara, anything else you'd like to add?
Well,
Anything else you'd like to add?
not only, then second part. The second part is that after commission of the offense, he came to the police station, informs the police, which was reduced into writing in the form of FIR. Then, my lord, the definition under section 8 will come. The conduct. Definition of section 8 of Evidence Act will come, the conduct. My lord, for that, we have our own Guwahati High Court judgment on this one. Or agree. There's one more. 2021 for GLT. Yes. Para 11 below. First part. And then I'll come to the recovery part also. Having carefully gone through the case law referred by so and so for the accused appellant, we find element of force in the same. In the case of so, 10 has been referred to. Criminal procedure provides for recording of first informations. The information report, as is not substantive evidence, it may be used to corroborate the informant under Section 157 of the Evidence Act or to contract him under Section 145 of the Act. If the informant is called as a witness, if the first information is given by accused himself, the fact of his giving the information is admissible against him as evidence of his conduct under Section 8 of the Evidence Act. So therefore, he has come and given the information that itself that he has killed that person. Now, my lord, para 12. That's his recovery of gun from the place of occurrence on the disclosure of the informant. In the Khetri Hemraj, Amaluk versus the state of Gujarat, Supra, the referring to so-and-so, Supra, it has held that the confession statement which was made by the accused to Sub-Inspector Rogia and which formed the basis of the first information report was not admissible in evidence as the same was seen by Section 25 of the Evidence Act. We have 1314. That first part, the recording of the information, first part, information he came and gave, the first part is covered by the Section 25 law. The second part, recovery of the gun, then that will come under the definition of Section 27. He cannot escape law. That small thing I am relying on, that Section 39 Arms Act. It is not of our High Court and this is not binding also, but it's of the Madras High Court of the recent judgment. A small judgment, my lord. Para 3, my lord. Yeah. There can be no dispute that for prosecuting a person for the offense under Section 25(1)(ba) of the Arms Act, previous sanction from the district collector is required under Section 39 of the Arms Act. That is why the court below in the impugn order had mandated that complaints should immediately obtain sanction. So therefore, my lord, my contention was, at the time of committal, my lord, the Chief Judicial Magistrate prima facie on discrepancy committed by the IO at the time of laying down the charge sheet ought to have directed the IO to obtain prosecution sanction. Fourth, important. Section 39 of the Arms Act states that no prosecution shall be instituted against any person in respect of any offense under Section 3 without the previous sanction of the district magistrate. It means that obtaining sanction is the condition precedent, my lord. It is a condition, my lord, precedent. That means, my lord, once in the FIR, you invoke Section 25 of the Arms Act, the process starts. In other words, even for taking cognizance, my lord, even he ought not to have taken cognizance, my lord. In other words, even for taking cognizance, sanction must be obtained. A cart cannot be placed before the horse. Therefore, when admittedly the prosecution has not obtained previous sanction under Section 39 of the Arms Act, the court below could not have passed the impugn order, my lord. This is my case.
Let us see what is the statement of the world. You can
The Arms Act 27.
Yes, Your Lordship, if I may be allowed to clarify certain things, Your Lordship.
Hmm.
Your Lordship is sitting in appeal with regard to acquittal of the accused, Your Lordship. Now, the charge was framed only under section 302, Your Lordship.
Yes.
The trial proceeded under only 302 and he was acquitted of the charge under 302, Your Lordship. From the framing of the charge till disposal of the case, Your Lordship, the Arms Act was never taken into consideration. Why? Because when the court was taking cognizance under section 39, Your Lordship, there was no prosecution sanction, and therefore the Arms Act itself was the framing of charge did not include the Arms Act. The Arms Act goes, Your Lordship. Now the prayer of the appellant in this appeal is for the retrial of the case only on the ground that prosecution was not sanctioned at that point of time. My query before this honorable court is the cognizance, the prosecution sanction stage comes only at the stage of taking of the cognizance of the case, Your Lordship. If the prosecution sanction was not issued at court has taken cognizance and the trial was conducted, it would amount to nullify of the entire trial, Your Lordship. But since the prosecution sanction was not sanctioned and the court, while while taking framing of the charge, had rightly taken the ground that since prosecution sanction, which is mandatory under 39 of Arms Act, was not issued, therefore the Arms Act was removed from the charge, Your Lordship. Now, Your Lordship will see that there was no procedure lapse as such. If the trial was conducted, if the prosecution sanction was not given and the trial was conducted, it would be a good ground even for the accused for nullifying of the entire trial and quashing of the case, Your Lordship. But in acquittal, how can that be a ground for retrial, Your Lordship? There is no procedure lapse. Sanction was not granted and therefore cognizance was not taken, which is mandatory under section 39. So there is no question of trial, retrial, Your Lordship. Now, when the charge was framed only under 302, Your Lordship, and he was acquitted from the charge of 302, Your Lordship, Your Lordship sitting on an appeal only with regard to charge of 302, not under Arms Act, Your Lordship. So the question of getting into the Arms Act, if the gun was licensed or not, is not a question in this appeal, Your Lordship. Now, secondly, if Your Lordship will see, even if for a time being taken into consideration the reference of arms and the license of the gun, Your Lordship, of the accused, Your Lordship will see that since the trial was conducted only under 302, while conducting the trial, the court has taken suo motu observation of the fact that this person was possession of certain arms. However, that violates that he has stated in his statement that he had gone for hunting in the forest, Your Lordship. The court has taken suo motu consideration that since the arm license cannot be used for hunting, and therefore his arm was to be directed for confiscation, Your Lordship. Not at all related to this case, Your Lordship. Your Lordship will come to page number 49, para 28, Your Lordship.
Gun is the main weapon for murder.
Yes,
Then cognito of the thing begins from here.
Yes, and therefore prosecution sanction in since the prosecution sanction was not issued, the Arms coming under Arms Act was to go by, Your Lordship. If Your Lordship will come to page paragraph 27, that is the view in this case, Your Lordship. In view of the above discrepancies, I am of the considered opinion that the prosecution has failed to prove guilt of accused person that he has committed the murder of the deceased. Accordingly, accused so-and-so is entitled to be acquittal. This was in the judgment. Now, the suo motu observation, Your Lordship, will come to paragraph 28. Before parting with the records of the case, it is observed that the accused so-and-so is holder of an arm license and he possesses the SBL gun. As from Arms Act 1959 and rules made thereunder, under no Arms Act can be issued for purpose of the hunting. It is prima facie proof that so-and-so has used this license arm for hunting. As such, this is a fit case requiring cancellation of the arm license issued in the name of so-and-so. Your Lordship will see that the acquittal was only with regard to the evidences of the prosecution witnesses, Your Lordship, not of the Arms Act. And why the Arms Act was never taken into consideration? Because the prosecution sanction was never taken into, never brought before the court who has taken the cognizance.
Anything else you want to say?
Yes, Your Lordship. Now, just a small, yes, Your Lordship, that prosecution sanction is against a person, Your Lordship. Now, during the investigation, Your Lordship, he has said that his license was missing, Your Lordship. And therefore, the IO has clearly stated in his statement that therefore, since the license was not there, therefore, he could not seek for prosecution sanction, Your Lordship. Now, my question before this Honorable Court is, can a court forcefully direct the investigation officer to procure a prosecution sanction, Your Lordship? Prosecution sanction is to be by the investigation officer. The court can just intimate that in this case, to take cognizance, prosecution sanction is necessary, Your Lordship. If the IO does not provide the prosecution sanction, Your Lordship, the cognizance cannot be taken as Lordship. The citation given by my learned senior counsel is also with regard to where the prosecution was not granted and the trial proceeded, Your Lordship. And therefore, it was quashed and a retrial was directed by the court. Not a case of where the prosecution sanction was not granted, that the act itself, the charge itself was not
Since
taken into
gun is-
consideration.
arms is involved in this case, the case could not have been proceeded unless the prosecution.
Prosecution
sanction-
sanctions.
What is the citation? Says?
Yes, Your Lordship.
Mm.
Your Lordship will see the statement of the IO, who has clearly stated that during inquiry, Your Lordship, the license was the inquiries were made with regard to the license.
Yes, yes.
The
Before the
accused,
deposition.
yes, the accused could not produce the license, Your Lordship, and therefore, I have stated, Your Lordship, a prosecution sanction is not against the weapon, but against a person, Your Lordship. Now, if there is no license, Your Lordship, how can a prosecution, any prayer for a prosecution sanction be sought against whom, Your Lordship? That was the situation at the investigation stage, Your Lordship. Subsequently, when the charge sheet was filed, there was no prosecution sanction. And to take cognizance of offense and to frame a charge under the Arms Act, Your Lordship, at the stage of cognizance, not thereafter, Your Lord. At the stage of cognizance, it has to be seen that the prosecution sanction has been accorded or not. If not, the cognizance cannot be taken. If the prosecution sanction has been granted, thereafter the stage of cognizance come and the issue of process starts, of the proceeding starts. Now, in this case, it's very clear there was no prosecution sanction, and therefore the charges under Arms Act was clearly let go by the magistrate, Your Lordship. And only 302 was, the charge of 302 was framed, and the entire trial was conducted only under 302, Your Lordship, not under Arms Act. And therefore, the question of prosecution sanction at this stage does not come, because the prosecution sanction, the stage of prosecution sanction is only at the stage of taking cognizance, Your Lordship. In fact, the citation submitted, Your Lordship, it's a totally per contra to what has been prayed, Your Lordship.
Mr. Taran, anything you'd like to add?
No, may not kindly appreciate. In the first instance, I leave that arms part now. The second aspect is, a person has been murdered, person comes and admits his guilt, and prima facie so that by a particular weapon, a person has been killed. Even if it is not 302 case, it is 304 part 2 case. Prima facie. You cannot say carte blanche that person was not killed. On record, it is available. FSL report says, post-mortem report says, you cannot discard those primary evidences in this manner. The argument itself stands not on the footing to sustain my argument, my lord. Therefore, this court, my lord, under 386 of the CRPC has a power of reappreciating the evidences, can order for de novo trial. There is no harm in it, my lord. This court always have the power, my lord. And my lord, this one authority is there, my lord, that state versus Buraj, 2001 7 SSC 679 para 8 law. 2001 7 SCC 679 para 8. appellate court has plenary power for re-evaluating and reappreciating of evidences. And it can also order de novo trial. When there is a procedural propriety not being maintained or per se has been violated by the trial court, then this court has a power. Well, prima facie on the records available. Well, that order of the retrial, just I took out, below, I can furnish this judgment, below. Order of retrial can be done in this 1964, below, SCR. 1964 SCR 926. It says when the original trial was not conducted in the fair manner, vitiated with the procedures, the court has a power to direct de novo trial. And 386, my lord, I have already pointed out. Secondly, my lord,
And in this point, just you see, the accused after commission of offense, of course, after a gap of about 6-7 days,
4 days, 5
4
days,
days.
5 days.
5
He
days,
was hiding in the jungle because, my lord, this 4 days.
reported before the inspector, one inspector P. Kalita.
Kalita, Mr. Kalita was
Kalita was never been examined.
never been examined, my lord. Procedural propriety is there, my lord.
And it appears that the accused has disclosed
Correct, my lord.
all those before this Inspector P. Kalita only. In the initial period of his surrender before the PS.
Yes. Then, my lord, also see declining to record
And
164 statement.
because prior to his surrender before the PS, nobody knew about where the weapons
Nobody
were
knew,
kept.
Lord. He
So
came
only
and
after
disclosed.
that only. So the action started.
Yes, my lord.
Recovery of weapons, exhumation
Everything.
of the dead body of the deceased. So he should have been examined, this person.
Oh, my lord, that I have argued one matter on this particular point only, that Mania Taku, my lord. That judgment I can share, my lord. That is a case argued by me before this division bench. Mania Taku versus State of AP.
And then since this inspector has not been examined,
Correct, my lord.
and then the statement or the disclosure of the accused could not be proved, how do we appreciate?
Then my lord will see that even 164 statement was also not recorded.
164 not recorded.
That is requirement under law, my lord. There was an application and there was a denial. My lord, I conclude my argument and my lord may pass any of.
For the fault of the prosecution and the eye of the case, because eye of the case, or this inspector,
And IO of the case died because of this, after this incident, after.
okay,
He met with a car accident and died.
immediately, because it was only on the basis of the disclosure of the accused only the arms was recovered. But then when it was during the investigation period only, the IO could have been asked this because he was still under police custody, could have asked to leave. And that having not done also, because
under 27 of Evidence Act also probably it's difficult.
Well, I didn't pass any order because as an officer of the court, I had tried my best to assist whatever they submit also.
May I submit, my lord?
Yes, please.
The learned appellant, counsel for the appellant
Hmm.
is seeking for retrial on the basis that the prosecution case was not proper, there was no sanction.
Hmm.
Now, in what cases a retrial would be done? On the reverse, suppose it was a case that there was no prosecution sanction, but still the trial proceeded under Arms Act. Suppose in such a situation, the trial itself would have been a nullity. But in this case, because prosecution sanction was not there, the trial did not proceed on Arms Act, it proceeded only on 302. That my learned friend has already said. So a case that has proceeded not on Arms Act and therefore not a nullity it cannot be a ground to seek for retrial, to order for retrial. Number one. Number two, from the records, it shows that the person, the accused person, has after the incident, he was the one who informed the villagers. He was the one who led them to the PO and helped in evacuating the person. He was the one who later on surrendered before the police. The incident happened on 27th of February 2016. Oh, sorry, was it 2017? But he surrendered on 4th of March 2017 by himself. The family members did not even lodge an FIR at any point of time. It was he who brought everything on record. And he's saying that just because a gun was used, just because somebody died, his defense, the accused person's defense, was that it was done by mistake because he thought it was a wild animal. That was his defense. He never denied that he never used any kind of tactics in order to save himself. He was the one who brought everything on record. Now, the trial court has also taken this into consideration that he did this out of mistake. Now, in order to come within the definition of 304 IPC, first, it has to be the satisfaction of the definition of the 299 has to be taken into account. Now, what 299 says? For a culpable homicide not amounting to murder. Number one, intention to kill. Number two, intention to cause such bodily harm that may lead to death. Number three, knowledge that whatever he's done is likely to cause the death of a person. Now, the death, the definition of death in the IPC is death of a human being, not of an animal. Now, he has to know from what transpires from the records is that whatever knowledge he had was a knowledge that he was going to kill an animal, not a human being. Now, these three characteristics are absolutely absent in the case. So the learned court has rightfully acquitted the accused person. That is my submission on the merits. So therefore, your lordship will see the records, the statement of the witnesses also. None of them, in fact, one of the witnesses has even said, one Mekagadi has even said, I don't think that he had the intention to kill the person. There is no finding that he had any intention, in fact, not even a knowledge that he was going to kill a person, that whatever he's doing is going to bring a danger to the person of a human life. Even that is not there. So how can he be convicted under 302, under 304 even, much less under 302? All these ingredients are absolutely absent. So therefore, the trial court has rightly acquitted the accused person. And like I said earlier, this is no case for retrial because the trial could not have been held to be a nullity because the trial did not proceed on in spite of lack of prosecution sanction under the Arms Act. Obliged.
Lordship, I would like just to clarify the submission made, Your Lordship. First of all, the submission being made that 164, if the application is made for 164, it has to be recorded. That's absolutely wrong, Your Lordship. The discretion is upon the accused that he wants to confess or not. Firstly, Your Lordship. Secondly, Your Lordship, the submission made that the informant P. Kalita was never examined, Your Lordship. Now, Your Lordship is well aware in many of the cases, Your Lordship, by the apex court clearly state non-examination of complainant or even of the IO is not fatal to prosecution sanction, Your Lordship. They'll have to show that what prejudice has been caused to them if the examination was not taken, Your Lordship. I have the citation, Your Lordship. May take the leave of the court to provide it in the later stage, Your Lordship. Secondly, Your Lordship will see page number 6, Your Lordship, which is the charge sheet, Your Lordship. The prosecution witnesses are of 7 numbers, Your Lordship. Lordship will see all the prosecution witnesses put forth by the state has all been examined, Your Lordship. There is no lapse on the procedural path with regard to the investigation, Your Lordship. The only ground that they are taken with regard to the second ground, Your Lordship, is that the general exception under 79, Your Lordship. Like for them, they are saying that the exception taken by the accused that it was a mistake. Actually, it was not a mistake, and it was an intended murder, Your Lordship. They could not, the prosecution could not actually justify with regard to the intention, the motive, Your Lordship. Only the gray area with regard to that is that though motive was not established, Your Lordship, the after act of the accused can be taken into consideration that as soon as such thing happened and he disclosed it to some of his friends, he ran away to the jungle, Your Lordship, and he was absconding. But that has also been clearly clarified in the 313 of the accused, that it was the deceased who had, after the incident happened, he could not quickly act and take the deceased to the nearby hospital. Why? Because the deceased had asked him to call his call villagers from the village, and during that time, it has the accused has gone, and as per the direction of the deceased, he had gone to the village to call them first, Your Lordship.
I thought, Milord, after the additional PP have made a submission, then I have given a rejoinder. Then after my rejoinder, he has proceeded with the rejoinder. Anyway, Milord, this happens, Milord, sometimes. I have nothing more to add on, Milord. But on the records and the materials that are available for my lords are prima facie a case for a de novo trial. That much, Milord. And I'll not make any counter submissions advanced by the learned amicus curiae, Milord.
Heard Mr. Retrial and counsel appearing for the appellant. Your ma'am, what's your name?
T. Ginny, Your Lordship.
Your additional public prosecutor
Additional purpose.
for the state. NMS and Duncan landed amicus for the,
Legal aid counsel for respondent two.
your legal aid counsel.
Yes.
Okay, legal aid counsel for the respondent number 1. Any EPS for the respondent number 2. Arguments are at length, order is up.
Keep it. The receipt or your please offer a cup of tea. That's true. Bye.
Item number 3.
May I, Your Lordship? Lordship, in this matter, our AG is appearing in this matter, so he instructed me to adjourn this matter to be listed on 22nd of April, July, Your Lordship.
Just. Challenging this PIL
Yes, Lordship, challenging upper 5.
with regard to the challenging this PIL that the Arunachal Pradesh unlawful activities within bracket prevention bracket close act 2014 is unconstitutional and out of Paris. Since the act is under challenge, the Advocate General of the state need to be heard, who is presently not available in the state.
Lordship, that
It is stated that the Advocate General of the state on the request of the Advocate General of the state released this matter on which date?
22nd of July, Your Lordship.
Lordship, here is one problem, Lordship, that I have my question was, my issue was that that inclusion of jurisdiction of the court. Lordship, in this regard, Lordship, my impression is now if this jurisdiction of the court is included in this act, then it becomes validated. So in order to validate it, they are looking for that amendment. Lordship, clearly in the reply paragraph 25, it is mentioned that when I raise the question of the jurisdiction of the court for not involving in this act, then the reply is, Lordship, that they will include the jurisdiction of the court in next amendment. Lordship, on that ground, they are taking the time, Lordship.
Necessarily, you see the assembly election justice over.
Lordship, maybe on this month, Lordship.
Right? Listen. 22nd July. When the state has said so that the amendment will be made, you should give them some time necessarily.
Lordship.
Bless you, Lordship.
Respondent number 7, 8, and 8. So I need some of them are available.
Who is appearing for the petitioner? Why it has been listed for orders today? Why it has been listed for orders today? Why? Just a minute. You are appearing for whom?
Respondent number 7, 8, and 10. Private respondent. We have all time appearing on the.
Seven, 8, and 10.
Yes.
You have entered appearance long back. Office note reflects that you have entered in 5th of February, not on 21st of June. Very clear from the office note. You filed your acquittal prior to that. What's your good name?
Hang on.
Okay. List on. July 24th. Respond number 7 and 10, 7, 8, and 10. Self-filed their affidavits, if any, on or before. July 26th. On or before 22/07/2024. Petitioner shall take steps. Now, peruse the office note dated 13/02/2024. Notice on the respond number 9, return unserved. Registry shall take, sorry, petitioner shall take fresh steps for service of notice on the respond number 9, providing its correct and proper address with requisite postal stamps on or before 25/06/2024. List accordingly. The interim observation made earlier on 22/12/2023 shall be enforced until further order. Yes.
My lord, I beg to mention item number 7, my lord.
Hmm.
My lord, here I request to file the affidavit, my lord. Wherever is comment I received, my lord. 2 weeks time may be granted, my lord. I've taken consent from the petitioner, my lord.
So. Mr. Prabhu, you are appearing for whom?
My lord, I'm appearing for respondent 3, 4, and 5, standing counsel of health department, my lord. 3, 4, and 5. My lord.
Notice in this case was issued. Way back on 11/08/2023. And the respondent numbers 3, 4, and 5 in the health department of the state is yet to file their affidavits. Last chance granted to the respondents number 3, 4, and 5 to file their respective affidavits, if any. Such affidavits shall be filed by those respondents on or before 16/7/2024. List on 22nd.
Deeply obliged.
Why isn't it listed for hearing today? At whose instance? Hmm? Why isn't it listed for hearing today? Was it fixed earlier? 2019 matter, 2021 matter. When did you retire? When did you retire? Not aware. That is not the issue. See, the petitioner is suffering for non-receiving of pension. Who is appearing for the government here in item number?
Lordship, I'm sorry, but we are not ready today. This very meeting.
Petitioner retired as what? As a mechanic.
Pardon, Lordship.
Petitioner retired as a mechanic.
Lordship,
It appears.
Lordship.
He was not the disbursing authority, nor he was the person concerned to assess his own salary. Because of some wrong done in refixation of his salary, he was
Yes,
paid his salary. Now, after his requirement, you want to recover that amount. Is it permissible in law? Law is well settled in this matter. So many judgments have been passed by the Honorable Apex Court. The man retired in the 2020, and now in 2024, see, the man is running from pillar to post for his salary, for pension.
Lordship. Lordship, can
This
it,
matter is
can it be next week, Lordship?
Monday. You see, because the law is settled here.
I,
After a person retires, he cannot, particularly when it was not at his fault. Neither
Lordship.
is a disbursing authority, nor is the person to assess his own salary.
Lordship.
There was a wrong mistake committed in a fixation of his salary. You have paid him. After his retirement, you cannot recover. And that should be regularized, in fact. That's the law.
That's true.
That's what the Apex Court have settled, and in fact, that judgment has been circulated through all the departments. These are four-person mechanic grade 4. If you want to ask those people to come to the court daily, what will happen?
Lordship, next week, because
Monday, any idea? Any idea? Monday, how many matters?
Audit and Pension have also filed the affidavit.
The other matter 24, it's not your case. You cannot, the court cannot pass any order directing the government to frame such rule for benefit you. But the next case is in your favor. Monday or Tuesday.
Yes.
Yes. When did you appear last? How many times you have taken to file affidavit? You are appearing for response number 6. So you appeared in you filed Okalattam on 3rd of January 2024. And from January to June, you could not file your affidavit. The response number 3 is yet to file an affidavit in this matter, though they have entered appearance in this matter on 3rd of January 2024. Last chance granted to the response number 3 to file its affidavit. List on 22nd, 23rd. The response number 3 shall file its affidavit, if any, on or before 18th of July. Item number 10. Yes. You want to file rejoinder? Where will you file it? Okay, give us a date by which time you'll file it. Tell us. Give us a date. We'll fix it accordingly. Give us a date. Give us a date. He is from which area? Okay, Anjaw district. Okay, we understood. Okay, file your reply by 23rd of July, more than a month. No try. It's a 1 month. Nothing. Nothing. You get it? Tell him that the case will be dismissed if you do not file the rejoinder. He will run. Petitioner shall file its rejoinder on or before 23/07/2024. List on 26th or 25th. 25th. Yes, ma'am. Any idea why it has been listed today? Why it has been listed today for orders? Let us see. Let us.
Your Lordship, they have sought time to find rejoinder, Your Lordship.
Item 20, item 16.
Yes, Your Lordship.
From 2nd August 2023.
Yes,
From
sir.
2nd August 2023, you are taking time to file rejoinder.
Yes, that is there, Your Lordship. Actually, he's just because of medical emergency, he have to be out of station. That's why by
From 2nd August 2023, we are in end of June 2024, ma'am. List this matter for admission on 24th of July. Petitioner may file a rejoinder, if any, on or before 18th July. As it is seen that since 2/8/2023, petitioner is taking time to file rejoinder.
Item number 1.
Yes.
May I sign? My lord, page number 27, my lord. 27, this is my lord. Annexation number 2, page 27, my lord. This is transfer order, my lord. May I read this, my lord? My lord, I beg to indicate one thing in this particular page, my lord. Down, my serial number, my lord, will find at 3, my lord. I am at 3, my lord. Oh, sorry, 4, my lord.
Mr. Parmani,
My lord.
please come to the order passed by the court earlier. Read para 6 and para 7. Page number 34.
My lord, second. On the other hand, Mr. Sasas has submitted the ground projected by the petitioner like joint posting, alignment of the husband as well
Ailment. It should be ailment, it's very wrongly typed. Ailment.
of the husband as well the meet academic session of the Harshilin are matter to be considered by authority in accordance to my lord. My lord, this is the is
Please
my
go
lord.
ahead, please.
Therefore, the read petitioner desires as the transparent posting of an employee is an invoice of service by.
Now the observation of the court. Can you read?
Now, considering the above submission of the Learned Council party, this court by no reason to interpret transparent posting of the dated 5/10/23. The grounds sought to be the petition are matter to be considered by the appropriate authority, taking into account of the welfare of its employee. It is noted the petition has submitted her representative before the secretary such and such Women and Child Development Department, Government of Arunachal Pradesh. In view of the fact and circumstances of the matter, this writ petition is disposed of with direction to the petitioner to pay representation before the Director, Women and Child Development Department, Government of Arunachal Pradesh within 3 days from today. On such filing of representation by the petitioner, respondent to Director, Women and Child Development Department, Government of Arunachal Pradesh shall consider and dispose of the representation within 7 days till the disposal of representation by the respondent to status quo in respect to the petitioner shall be maintained. However, it is made clear that the transfer posting of respondent force shall not be disturbed.
Now, please come to page number 40.
40, my lord. This, my lord,
This is the impugn order.
this is impugn.
And when it was issued?
Issue on 26 December 2023, my lord.
26 December 2023. And when the session of the school starts in the state of Arunachal Pradesh?
It start June, July, my lord. June, this
June,
June.
July. So after April, the school sessions are there.
My lord. Yeah,
Now you have been released.
Yeah, I've been released. That's why, my lord, my issue before this today, my lord, my issue, my lord, I am saying I considered, my lord, yes, my lord. Now, my lord has seen the judge order of this court, my lord. The category fee, my lord, of the government, my lord, before this honorable court, my lord, was that, my lord, the issue raised by me, my lord, the alignment of the my husband, my lord, child education of child, my lord, that
Say the authorities considered.
that need to that, my lord.
That was in a certificate of sometimes in September, 3 months are over. Now it is more than 9 months.
No, that's why, my lord. My lord, kindly give me 2 minutes. Now, once, my lord, a submission has been made before this honorable court, my lord, to consider my grievances, my lord, before the fairness, my lord. My humble understanding, the fairness, my lord, of the respondent, my lord, before to the this honorable court, and me, my lord, demand that, my lord, that this that representation, my lord, my grievances, my lord, need to be considered reasonably, my lord, not arbitrarily, my lord. What happened in this case, my lord, is page 40, my lord. What while disposing the representation, my lord, the authority, my lord, I will read this, my lord. This order was passed, my lord. At para 4, my lord, and whereas joint posting may be option either by spouse of both if both husband and wife are government servant. In this case, the petitioner is transferred in the exigency of public service, my lord. This is contrary to the record. That was I was indicating, my lord, to the impugn transfer order, my lord. That was on the request of the particular 2 officers, my lord, that transfer order issue, my lord. Exigency of public service, and as such, her husband may option for joint posting, my lord. At same station where wife is transferred if post is available, my lord, or at the nearby station where post is not available. Now, therefore, my lord, I immediately, after this representation, I submit under representation saying that, my lord, where now I have been posted, my lord, there is no post of post on my husband, my lord. Accordingly, I submit. Now that the representation, my lord, is still pending for disposal by the competent authority, my lord. Therefore, my lord, I am before this honorable court, my lord. Ultimately, my lord, once, my lord, categorical stand, my lord, has been made by before this honorable court, my lord, that they will consider my grievances, my lord. Now, fairness demand, my lord, that representation, my lord, need to be considered reasonably, my lord, not arbitrarily, my lord. Now, in this case, my lord, transfer order, my lord, was issue in my place on the instant of, my lord, some third party, my lord. That clearly evident from the record, my lord. Down below, my lord, in the page number 27, my lord, that is reflected, my lord, the as it transfer order was issue instead of the one in serial number 1 and 3, my lord, they will not entitle C&E, my lord. Now, my lord, the government, my lord, being a department being a welfare state, my lord. Once they are considering the grievances of, my lord, other employee, my lord, on their request, my lord, they are transferring me, my lord. My humble submission, my lord, and stand has been taken before the court, my lord, to consider my grievances, my lord. My humble submission before today, my lord, is they need to be considered fairly, my lord, not unreasonably, my lord. They are saying that my husband can option for their, my lord, my posting place, my lord. Whereas, my lord, there is no post as such, my lord. Therefore, my lord, my humble submission, my lord, at least, my lord, we direct, my lord, to consider this my representation, my lord, this pending representation, my lord, at page number 42, my lord. This representation I submit immediately after getting this the representation disposal order, my lord. Once, my lord, my humble submission is made, my lord, before this I will go to consider my grievance, my lord. That need
Your
to be
husband is serving in which department?
education department, my lord. It college, my lord. As a assistant professor, my lord. Pasigat, my lord. Jane, but now in Namsai that is not available, my lord, and there is no he was not available, my lord. Now he is suffering from, my lord, TB, my lord. Now in such situation, my lord, my humble no, though, my lord, I have no impossible, but once, my lord, my humble understanding, my lord, is categorical stain, my lord, has been made, my lord, this all, my lord, grievances need to be considered competent authority, my lord. Now that, my lord, the fairness demand, my lord, fairness to this honorable report and fairness to me, my lord, by the respondent, my lord, demand, my lord, that need to be considered reasonably, my lord, not unreasonably, my lord. If there, in absence of any post, my lord, at my posting place, there cannot be option for my husband to join posting with me, my lord. So my humble submission, my lord, will direct the respondent, my lord, to consider my representation, my lord. Taking to my categorical stand in my representation dated 29/1/2024, my lord, that I submit immediately after this,
Yes.
my lord.
But, as per the earlier court's order, the court has clearly observed that there is no reason to interfere with the transfer order, impugn transfer order. And on top of that, the court has also made it clear that the posting of the respondent number 4 shall not be disturbed. That is, two aspects have been clarified, my lord. Now, my lord, if this honorable court now either stays or that will have a contrary view, my lord. On top of that, the
Pardon,
legal.
Mr. Alfarmi, counsel appearing for the petition. And Mr. Randatun, you are holding as standing counsel,
No, my lord, for 1 to 3, additional AG.
additional advocate general of the state for the respondent numbers 1, 2, and 3. Petitioner is a supervisor.
My lord, before passing, I want to clear one, my lord. About, my lord, disturb respondent, my lord. I have made a categorical statement, my lord. He is already joining in his place of posting, my lord. Now, in at Pasigat, my lord, where I am want to serve, my lord, there's a one vacant post of server that I have also included a document at page number 46, my lord. He retired on this December, my lord. Post is available, my lord. Even if, my lord, suppose, my lord, by considering my representation, they want to let me stay Pasigat, that will not affect the respondent for, my lord. Therefore, I have made a category statement in my petition, my lord. There is no question of disturbing the respondent number 4, my lord.
While petitioner was serving as a supervisor in the integrated child developments supervisor in the IC integrated child development scheme project at Pasighat. The Director of Women and Child Development Department, Arunachal Pradesh, by order dated 05/10/2023, by order under number liquid. Side report, page 27, reporters. Transferred her from Pasighat and posted her in the same capacity at Namsai. Agree with her said transfer order. I got out of simple circle. And transferring the response number 4 from Namsai posting her in place of the petition, directing the response number 4 to move first, relieving the petition. Against the said transfer order dated 5/10/2023, the petitioner preferred a writ petition being WPC number 610/2023, stating that her husband is suffering from tuberculosis. Her children are in the mid-academic session, and she has already filed a representation before the director which was yet to be considered. After hearing the court by order dated 18/12/2023 disposed of say WPC number 610/2023 preferred by the petitioner, directing the petitioner to file a representation before the Director, Women and Child Development Department, Government of Arunachal Pradesh within 3 days from the date of this said order. Observing further that on such filing of representation by the petitioner, the said Director, Women and Child Development Department, Government of Arunachal Pradesh, shall consider it and dispose of the same within a period of 7 days. Until then, until the disposal of the representation of the petitioner by said director, status quo in respect of petitioner to be maintained. Full stop. In the said order, dated 18/12/2023, the court categorically observed that till disposal of the representation, category observed the transfer and posting of the response number 4 shall not be disturbed, and specified that the court did not find any reason to interfere with the transfer and posting order of the petitioner dated 5/10/2023. Pursuant to the said order of the court, the petitioner submitted her representation before the Director, Women and Child Development Department, dated 2012/2023. The Director, Women and Child Development Department, after considering the submission of the petitioner, disposed of the same on 26/12/2023. allowing the petitioner remain and serve at Pasighat ICDS project till completion of the academic session 2023-2024 of her minor school-going children. It is stated that the academic session in the state of Arunachal Pradesh is from May to April. In a said order, dated 26/12/2023, Director, Women and Child Development Department, Government of Police, Arunachal Pradesh, APP Limited. Category observes that the petitioner has already completed 3 years of service in her present place of posting at Pasighat, that is beyond the prescribed tenure of 2 years as per government norms. And further, the transfer of the petitioner was made by the order dated such and such in exigencies of service. Pursuant to the said order of the Director, Women and Child Development Department, Government of Arunachal Pradesh, the 26/12/2023, the petitioner has been released from her service at Pasighat. By order dated 10/06/2024 with effect from 11/06/2024, issued by the Child Development Project Officer, Pasighat ICDS project. The petitioner has now filed this writ petition on (20/06/2024), stating that the Director, Women and Child Development Department, Arunachal Pradesh, did not consider her representation dated 2012/2023 reasonably as the said authority in its order observed that the husband of the petitioner should approach the concerned authority for his transfer and posting with his wife, ID petitioner, to be at Namsai, though there is no such equivalent post is available at Namsai for her husband. It is also submitted by the petitioner that a post of supervisor is lying vacant in the Pasighat ICDS project since 1st January 2024 as one Srimati Yamen Jerang, supervisor in the office of the CDPO Pasighat ICDS project, retired with effect from 31/12/2023. The petitioner agree with the said order of the Director, Women and Child Development, Government of Arunachal Pradesh, preferred submitted a representation dated 29/01 on 29/01/2024 and stated that same is yet to be disposed of. Hence, this petition by the petitioner for paying and just amongst other statement. For setting aside our transfer and posting order dated 05/10/2023, issued on 17/2023 by the Director of Women and Child Development Department, and to consider her representation. And in the interim, to stay the impugn transfer or her impugn, to stay the impugn transfer order dated 5/10/2023 of her transferring transferring her from Sasan to such Pasighat to Namsai, as well as to stay the release order dated 10/6/2024 till the final day of this petition. This court, in its order, earlier order, dated 18/12/2023, passed in WPC number 6102023, as noted above, at para 7. Specified that the court did not find any reason to interfere with the transfer and posting order of the petitioner dated 5/10/2023. The said order is not under challenge before any higher forum by the petitioner. Moreover, as seen from the order dated 26/12/2023, the prescribed tenure of a government employee in a particular place of posting is for 2 years, whereas the petitioner already served more than 3 years, completed 3 years as a supervisor of ICDS project at Pasighat. Considering her representation dated 20/12/2023, the Director of Women and Child Development, Government of Arunachal Pradesh, already allowed the petitioner to remain at Pasighat ICDS project till completion of the academic session of her minor children, school-going children, for the period from 2023-2024, which is already over, and accordingly, the petitioner was already released from Pasighat with effect from 11/06/2024. In view of the above, the court is not inclined to interfere with the impugn transfer order of the petitioner dated 05/03/2024, issued on 07/03/2024, passed by the Director of Women and Child Development Department, Government of Arunachal Pradesh, transferring her as a supervisor in the ICDS project from Pasighat to Namsai. It is up to the petitioner. Before that, moreover, this petition was filed after her release from the post of supervisor ICDS project at Island 2006. Release was in session 11/06. In view of the above, the court did not find any such merit in this said petition, and accordingly stands dismissed. However, it is up to the petitioner, after joining at Namsai, she may prefer any such representation before the respondent authorities, particularly the Director of Social Investigative, Women and Child Development Department, Government of Arunachal Pradesh, if so advised or considered. Or yes.
My lord, I humbly believe, my lord, dismissal of repetition, my lord, will not bar my lord to direct the respondent to consider my representation 21 to 20.
First is on, that's the law of the law laid down by the Honorable Apex Court. You first have to join your prospects, post of posting. Then you have to file. It is other way around.
My lord,
The Supreme Court has clearly laid down the law that in exceedance of service, when somebody is transferred, you first have to join the post of posting first.
True,
Then
my
have to file representation.
but my
That
lord, truly, my lord.
to join first.
Truly, my representation, especially prayer was made for my lord on him, joint
You-
posting with my
You
husband.
join NAMSA, then you file. You first join NAMSA, then you file.
Ovulation.
Item number 2.
Your Lordship, I am appearing on behalf of the petitioners. And Your Lordship, the petitioners are the applicants applied under the compassionate appointment in Arunachal Pradesh Police. Your Lordship, this writ petition, the petitioner has filed to challenge the impugned notice dated 8/6/2024 issued by the Office of the DGP, Director General of Police, Government of Arunachal Pradesh, through the Office of Director General of Police, Itanagar, wherein arbitrarily and in utter violation of the terms and conditions envisaged in the scheme for the compassionate appointment has added 2 new criteria, that is physical efficiency test and the written test for the appointment under the compassionate appointment in Arunachal Pradesh Police. And your Lordship, point number 2, impugn report dated 7/6/2024 submitted by Committee of Police Department, wherein the age of the candidates or applicants are calculated as on 6/6/2024.
Where is the order or the notification?
Your Lordship, it's in Annexure 1. Your Lordship may come to the page number 31.
Page number?
Page number 31, Your Lordship. Page number 31. Your Lordship, here the 2 new criteria has been added. That is, the date of PST PET has been fixed on 26/6/2024 at PTC Bandardewa, and for those qualifying PST and PET, the date of written examination has been fixed on 30/6/2024. Your Lordship, this is a newly created recruitment rule. It is created on 8/6/2024 itself. And the department is trying to implement this new recruitment rule retrospectively, who have already applied before the change in the recruitment rule. Your Lordship, this is the main contention of the petition. And Your Lordship, some brief facts and backgrounds of the case. Your Lordship, on 9/7/2019, one notice was issued to the compassionate applicant to report in PHQ for final selection. Your Lordship, in 2019, there was no such criteria as
This post of 35 were advertised when? When the post for compassionate appointment in the police department was advertised?
Your Lordship, it was advertised on the 28 April 2023. Last year it was advertised. Your Lordship, it is in Annexure. Annexure 13, page number 89, Your Lordship. Annexure 13, page number 89. Your Lordship, here in this advertisement, there is no such criteria as physical efficiency test and the written examination. And after postponing this advertisement, only they have inserted 2 new criteria.
Have you challenged this notice of 10th of August 2022?
10th of August 2022.
Annex 12.
No, Your Lordship. Your Lordship, many a times.
Why you are agreeing?
Your Lordship.
Why you are agreeing with this order of 8th June? Why you are agreeing?
Your Lordship, I am agreed because the recruitment rules, policy, and the law should be applied in the prospective manner, Your Lordship, not in the prospective manner, Your Lordship. Your Lordship, this new recruitment rule should be applied for
What is that recruitment rule?
recruitment rule. Your Lordship may come to the annexure 2, page number 32.
What is new in this particular notice of 8 June 2024, page 31?
Your Lordship, the new is two new criteria has been added, Your Lordship.
Which are the?
That is physical efficiency test and written examination. Your Lordship may compare the annexure 1 and annexure 13.
Just a minute. PST and PET.
Yes, PST was already there, Your Lordship. And now PET and written examination has been added in the new rule.
PST and or PST oblique PET?
Yes, PST oblique PET, But before only PST was there. No such thing as PET was there.
Whether it has said it is PSC or PET.
It is PET. The new applied rule is PET.
This notification doesn't say both PST and PET. It says PST oblique PET.
Yes, Your Lordship, but they have liberty to enforce PET also in according to this
What
new
does the rule says?
rule says, Your Lordship. May I come to the page number 32, Your Lordship.
Page?
Page number 32.
This is not in the police department. This is administration. We are talking about the police department.
Yes.
In the last advertisement, it was on 28th of April 2023, Annex 13.
Yes, Your
It is,
Lordship.
applicants for compassionate should be eligible and suitable for the post in all respects under the provision of the relevant recruitment rules. Now, what is the relevant recruitment rules for police?
Your Lordship, may I go back to the background to make Your Lordship understand about the recruitment rule? Because there is no such recruitment rule in this appointment of compassionate ground.
This advertisement have you challenged?
Yes, Your Lordship.
The advertisement, the notice issued on 28th of April 2023, have you challenged?
28th of April 2023. No, Your Lordship,
You
because
have not challenged.
yes.
That particular notice clearly mentions about the provisions of the relevant recruitment rules. Kindly show us the recruitment rules.
Yes, Your Lordship may come to the page number. Your Lordship,
Just tell us a person.
Just give me.
Even if it is a case of compassionate appointment.
Yes, Your Lordship.
Can an underqualified person can be appointed?
Yes, Your Lordship, before the.
It was before, forget before.
Yes.
Now this advertisement clearly mentions the relevant recruitment rules.
Yes, Your Lordship.
For a post of head constable, constable, band, what is the relevant recruitment rules?
Your Lordship.
We are not talking about compassionate appointment. We are talking about the relevant recruitment rules. Which is that relevant recruitment rules?
Yes, for relevant recruitment rule, they used to, Your Lordship, they used to take the PST test. And they used to assess all the.
Please show us the relevant rules for appointment of constable.
The recruitment rule has not been annexed here also.
Yes, it has been
It's
annexed.
not annexed.
Do you have it or no?
No.
You don't have.
Yeah, here also right now I don't have.
Yes. Why you are government council? You don't have the rules. You must have. If you are a government council, you must have everything in your hand when you are representing the department. What is the recruitment rules?
Your Lordship, for the compassionate ground, the
Is
recruitment.
there any
rule.
recruitment rules for
There-
appointment?
yes,
There is.
yes.
Produce it on Monday. Because the interview is fixed sometimes on 26th. We'll have it on 27th, 24th for motion. Place us the relevant recruitment rules.
Your Lordship, this is not a normal recruitment, Your Lordship. This is a recruitment for a compassionate ground,
Those days
which
have
is
gone.
which is in financial distress.
Those days have gone.
Your Lordship, the eligibility criteria, the clause 5A, the family is in the first eligibility is the family is indigent and deserve immediate assistance for relief.
We are
from.
asking for the relevant recruitment rules. Show us the relevant recruitment rules for the post those are advertised in the year 2023.
Your Lordship, for the normal recruitment rule, there will be PET test.
Show us the relevant recruitment rules. Monday.
You
also tell us.
Can it be on Tuesday?
Not possible. It will be 25th, 24th.
Exam is on 26th.
That is the reason we will have it on 24th.
Much obliged.
Item number 3 and 4.
Yes, Madam Attorney, why it has been listed today? I forgot.
My lord,
For- Hmm. Yes,
it pertains to the
Hmm.
illegal act or the arbitrary.
yes, right.
On the last day, my lord heard me at length, my lord, but the
Yes,
government
I
advocate
know.
was not here.
Yes, wanted you to obtain the instruction.
Lordship. So far the petitioner is concerned, Lordship. Lordship.
See, what is the ground of the petitioner is that they have not been paid the 100% Solium. That's right. While assessing the land value
In the reassessment,
in the reassessment.
but the others have been paid, my lord, but it was paid on pick and choose basis, my lord.
Now,
Similarly
we
situated
have
persons
also
were paid,
seen-
but we have not been paid, my lord. That is my grievances, my lord.
On that day, we have seen that how the value has to be assessed under the
Lordship may come to my, in item number 3, Lordship, my phase 3.
item number 3,
Phase 3 of my affidavit, Lordship.
page 3 of your affidavit.
Uh,
4 and 5,
Is this affidavit, Lordship?
4 and 5. You appear for 4 and
Yes, 4 and 5. Lordship here, Lordship. After the receipt of the compensation, Lordship, and after deducting the government charges, Lordship, the disbursal was done by the Deputy Commissioner, Lordship. 359 beneficiaries were already given on paid payroll, Lordship, as part of his record. While it was underway, Lordship, compensation disbursal was underway, Lordship. CBI inquiry came into, Lordship. So after disbursing 359 beneficiaries, it was stopped, Lordship.
See, basically,
Lordship. After
it
that,
was-
re-verification was done, Lordship.
just a minute. What we want to know from you is, where is that order for the government after reassessment, after direction of the court?
Direction of the court, my lord.
Lordship, after the reassessment, as part this in the item number 3, the petitioner is concerned, she has been paid excess. As per Lordship may come to my page 5, para 6.
No, first of all, you just tell us under what provision of reassessment was made? Reassessment was made on the basis of 2013 Act, right?
In the, no, first assessment was made as per the 1984 Jumlan Act.
Kindly show us.
Reassessment.
Reassessment was, Lordship, done in as per, Lordship, this is as per the direction of the Commissioner Secretary Land Department only we have been dispersing, Lordship,
Right.
doing.
That is what we want
Lordship,
to know.
he is the right person to answer why the first part was given as in the 1984 Act, Lordship, on that basis. And the second part again in 2013. We have again this part we have written to the this one also, Secretary of Land Management also, Lordship,
Who is
saying that
appearing to the land
the
management?
half part is
Who is appearing for the land?
Dungmar Kamduk, standing council, Lordship. In my Lordship, item 4, we have
Mr. Kamdut
written to
appears.
the, yes,
No, see,
Commissioner-
basically, where is that book?
Book.
That day we had.
we have
First
explained that
volume of the Arunachal Pradesh Code, first volume. That's right.
the parts who have been Lordship,
Your Lordship, the standing council, he went back to home as he having some personal difficulties.
because Lordship item number 4, we have explained here, Lordship. Lordship, may in item 4, Lordship may kindly see item 4's item number 4, our reply, Lordship, 4 and 5. Land has not filed any affidavit, Lordship. Lordship, here I have explained from para 9 properly, Lordship. I have explained, Lordship. We have written to the Secretary Land also that since 359 has already been disbursed according to the 1984 Act, Lordship, and then this remaining after the re-verification has been, Lordship, directed. We have got a letter from the Secretary Land to disburse according to the LAR Act 2013. This is, I have annexed this also, Lordship, the letter also. In item number 3, Lordship, the petitioner has already been paid. In fact, she has been paid in excess, Lordship. In item 4, Lordship, petitioner has not been. Item 3, petitioner should not be aggrieved, Lordship, because she has been paid along with the Lordship. Solium. 30% Solium. Especially in para 7, we have clarified, Lordship. Oh, page 7.
You are representing the Deputy Commissioner, right?
Yes, Lordship.
Now, in your first assessment, while taking over the land,
Yes, Lordship.
Can you tell us when the land was taken over for the BCT road?
That part, Lordship, Lordship, this is BCT, Balipara Chardua Tawang Road, Lordship.
When it was taken over, because the land of the petitioners were taken over, in which year?
Taken over, Lordship, nowhere it has been this one, but
In
then
2012?
on March 31, 2012, PRO deposited an amount of 21 crore, Lordship.
It's okay, that is the reason you are asking me.
Yes,
Some amounts is basically at that point of time,
Lordship.
how many beneficiaries were listed? 300 something,
Beneficiaries, I have annex, Lordship.
359 beneficiaries.
No, this is the 359 is the beneficiaries who have already been paid.
So their lands were taken over in which year?
But Lordship,
You have issued some notification for taking over the land for the BCT road.
yes, Lordship, that must be. There must be.
Is it available in your record? So this amount was disbursed to 359 beneficiaries.
Yes, already disbursed. Yes,
Initially, a list was prepared
yes,
for in which there were 359 beneficiaries. And to them, you have paid the compensation, right? Thereafter, the beneficiaries increased or what?
no, Lordship, leftover beneficiaries, the disbursement was not finished, Lordship.
Disbursal was not finished.
Not finished. In between the CBI inquiry came into. So it has to be stopped, Lordship. All the documents
Now-
were taken away.
In total, how many beneficiaries were there?
Total beneficiaries, Lordship. Just a moment, Lordship. Lordship, they have given the beneficiaries who have been already paid. That only.
See, basically, it is the deputy commissioner who assessed the compensation and
Yes.
submitted the amount of compensation to the BRO.
Yes.
So for how many such landowners the estimate was prepared?
That is not here, Lordship. Only.
Difficulties, you know why?
Who
See,
have been paid. And Lordship, if Lordship come to the page number 27,
why reassessment was made?
359,
Why reassessment was made?
there was Lordship complaints
Complaints regarding what?
for Lordship, some were complaining that instead of this part, they are giving less amount, and then some were saying that for less land, some are getting
More amount.
more amount, Lordship.
So the beneficiaries, the compensation it was given was erratic. Say for 5 bighas of land,
Yes, Lordship.
10 bighas of compensation was given.
Lordship.
And for 5 bighas of land, say for only 3 bighas of compensation was given. So what made the deputy commissioner to make reassessment under the 2013 Act?
Take part the secretary's Lordship. Land management's direction, Lordship.
Land management directed the deputy commissioner to assess
8 part 2013,
13.
Lordship. Yes.
Now for the remaining landowners to whom it was to be paid, or for all such landowners whose land was acquired.
No, for the remaining, Lordship. For the remainings.
Okay.
That's
Now-
what we have raised that question in item number 4 also, Lordship, if you.
Now for the
Lordship say.
remaining landowners,
Yes,
when their lands were
Uh,
taken over by the BRO,
they were taken over altogether, Lordship. All of them.
fine, all were taken over together. Now the remaining landowners,
Lordship.
names were in the list or not? Earlier, when the assessment, the compensation was assessed by the deputy commissioner, the name of the remaining landowners or the beneficiaries were in the list or not?
They are the beneficiaries. They are in the list, Lordship.
They were in the list,
Yes, Lordship.
but they were not paid because of the CBI inquiry.
Inquiry, Lordship.
But some were paid, some were not paid.
Yes,
Now for the remaining people who did not receive the compensation amount, it was again directed to be reassessed.
yes, Lordship. Because
Now, where is that reassessment?
reassessment, Lordship, may come to the my item number 4, Lordship.
Yes.
This is the similar, Lordship, this one.
Okay, doesn't matter. Where is that reassessment?
Malon, can you come to item 3, Malon? This
Let
is,
us-
this
let
is a
us see.
misleading statement, Malon.
Let us, so because it is the reassessment was made by the deputy commissioner, let us see one by one.
No, it's for my 359. 359, 11 crore 57,000, 57 lakhs, this much amount was paid already.
No, no, no.
Remaining they could not pay.
Reassessment was done for all the beneficiaries, Malon.
So let us see the reassessment. Where is that
Oh, yes,
calculation?
yes, Lordship, that I agree.
calculation?
Reassessment, Lordship. Annexer F, Lordship,
Page, annexer,
page
annexer,
F, Lordship,
that is in the first writ petition,
second writ petition, Lordship.
annexer F. In your affidavit,
Yes, Lordship. Lordship,
page
page
number-
65,
page 65.
in item 4, Lordship.
Page 65.
Yes, Lord.
This is 344 or 345?
This is Lordship, 345.
345, page 65.
Yes, Lordship. Yes, 65.
No, how this calculation was made?
Lordship, this calculation is starting from page 72, Lordship.
Hmm.
Malon, may I please, my lord? My lord, in page 72, there are two parts, my lord. The
Hmm?
first, in page 72, there are two parts, my lord. My lord, kindly pay news, my lord.
We have seen that.
The first part is the first assessment, my lord, done by the ADC. And the second part is the reassessment done under the direction of this honorable court, where 100% solution had been given to the beneficiaries, my lord.
Lordship, what we say here is that prior to the CBI inquiry, some 359 beneficiaries were paid compensation as per the available copy of AROL, Lordship. Therefore, no further payments were made. Payments of compensation to the left out beneficiaries were made as elaborated in the above statements, Lordship. Lordship,
Now what happened?
how LAR Act was, Lordship? This one, Lordship, may kindly come to page 6, starting from,
Page 6.
yes, in this one, Lordship, my para 9, Lordship.
Huh. Yes.
Starting from paragraph 9, Lordship. Here it says the answering respondent begs to state that after the CBI inquiry came into effect, no further payments were made. As per the order of the Honorable Guwahati High Court dated 9/8/2012 in WPC so and so AP 2012, Secretary Land Management Govtop AP constitute a press board of under the chairmanship of the DC West Coming for completion of the correct assessment of valuation of the properties involved and submit a press report to the government. Reassessment report was submitted to the Secretary Land Management Govtop AP by DC West Coming by letter dated 12/4/2013. The same was returned by the Secretary Land Management by dated 30/10/2013 for re-verification of the compensation as per the res notified by the Govtop AP in terms of the res notified for highway projects in the state, which was basically at ₹11 per square meter for Jumland. In reference to the letter dated 30/10/2013, the Deputy Commissioner of West Coming by his letter dated 29/11/13 submitted to Secretary Land that the latest government notified rates are much lesser than the previous government approved rates, and also that age land compensation to many of the affected families has been already disbursed before the Honorable Court order based on the previous rates, and matter was submitted for further necessary action. A fax message by dated 31/3/2015 was received from the Commissioner Land Management Itanagar regarding punishing of differential cost between Law Act 1894 and Law Act 2013 separately for completion of payment of remaining compensation for construction of BCT Road under Dirang Circle. A comparative statement of cost assessment for left out beneficiaries was prepared in consultation with the ADC Dirang. The list prepared for left out beneficiaries was also verified and authenticated by the Gauburas of the affected families, and the comparative estimate matter was submitted to the Commissioner Land Management by letter so and so for further direction. In response to the letter dated so and so seeking further direction in the comparative cost assessment prepared comparing the assessment made as per the Land Acquisition Act 1894 and Land Acquisition Act 2013 in respect of the left out beneficiaries submitted to the appropriate authority by letter dated 3/8/2015. Government approval for the estimate of the compensation of properties as reassessed by the press board and as per the provision of Law Act 2013 was conveyed. Special approval for disbursement of the remaining compensation was also conveyed by the Secretary Land Management by letter dated 9/2/18, based on which the compensation to the remaining beneficiaries were disbursed. Lordship. This is totally,
Now that the beneficiaries now,
yes.
the second lot of beneficiaries,
Uh,
they have been saying that they have not been paid the 100% Solium.
Lordship, 100% Solium was never there. 30% Solium in the Lordship, if Lordship see, have a look at here, Lordship, just a second. 30% Solium was there in the earlier payment, Lordship, not 100%. You have stated
Here,
somewhere,
next, para eight,
Lordship.
page 8.
Yes, Lordship. Here, Lordship.
Hmm.
It is also observed that some petitioners were paid in excess when compared to the estimates prepared by the press board.
No, first paragraph at page 8.
The first estimates were prepared as per the provisions of the Land Acquisition Act, yes, Lordship, this one. The reassessment done by the press board under the chairmanship of TC assessed the value of the house property only without any particular Solium or interest. Government notification in regard to fixation of Solium under the Land Acquisition Act was also circulated by so and so, December 2000. And in the LAR Act, there is no such Solium, so Lordship. That's what we have said, Lordship.
In the first 359, you have paid Solium at the 30%
Yes, Lordship.
to their land value.
Yes, Lordship.
Now, with regard to the petitioners hearing, who are the second lot of beneficiaries.
Yes,
Right?
left out
Okay.
parties, Lordship.
Have you paid them any Solium?
Lordship, as per 2013 Act, Lordship, we have said Solium. Lordship, it has been paid as per the Lordship.
Land Acquisition Act. That day you have given Land Acquisition Act 2013 and this year, I think so. No, 2 acts are there. Because here. Right of fair compensation. Do you have the 2013
Yes,
Act?
Lordship. Yes.
Please come to section 27.
Yes, Lordship. The collector, having determined the market value of the land to be acquired, shall calculate the total amount of the compensation to be paid to the landowner whose land has been acquired by including all assets attached to the land.
So land value plus any house, any trees standing over it or any orchard, whatever.
That is always taken.
Right.
Lordship.
Now-
That is always taken.
Now come to 29, next page. That relates to determination of value of things attached to the land or building,
Yes.
right?
Lordship.
Now section 30. Kindly read.
The collector, having determined the total compensation to be paid, shall to arrive at the final award imposed a Solium amount equivalent to 100% of the compensation amount.
Explanation.
Lordship.
Explanation.
Yes, Lordship. For the removal of those, it is hereby declared that Solium amount shall be in addition to the compensation payable to any person whose land has been acquired. The collector shall issue. Lordship.
How much solution you have given? In
Lordship.
your affidavit, what you have said at page para 9 at page 8 is that the reassessment done by the fresh board under the chairmanship of the deputy commissioner assess the value of the house properties only without any particular solution or interest.
Lordship, in item 3 also, they have categorically stated that it is pertinent to mention that no payments were made as part of assessment made by the press board. The left out
Where you have mentioned?
beneficiaries were paid 8 part of LAR Act 2013 in terms of the government direction. Government is the land department, secretary land.
No, that is, but have you assessed that 100% solution? Have you assessed?
That part, Lordship.
Because you have said the reassessment done by the press board under the chairmanship of the deputy commissioner
Yes,
assess the value of the house properties
yes, Lordship.
only without any particular solution or interest.
Yes,
So that means solution and interest was not calculated. Now, as for the provisions of 2013 Act, you are supposed to pay solution or not.
Lordship, it is from this, it cannot be, nothing can be make up exactly how many beneficiaries were there also, because in item number 3 also, Lordship.
That is the reason we are asking you, where is your calculation? Your calculation.
Calculation, Lordship,
Because the deputy commissioner headed the board.
yes.
Where is that calculation?
Seventy-two. Item number 4.
Now, please come to page number
81.
in your affidavit. Page 13. This is in 2012,
Yes, Lordship.
right?
Yes.
Now, after recalculation in 2018, where is your assessment? At page 65 or at page somewhere else?
Lordship, 67 is reassessment, Lordship, no?
No, that is in 2000, but as per affidavit, you have said you have done it in 2018. Your own paragraph 9.
October, Lordship,
Page number 7. Page number 7.
yes, Lordship.
Where is the letter of 3/8/2015?
Lordship, this 18 is for disbursement, Lordship.
3/8/2015, you have made a reassessment. Where is that letter?
3/8/2015.
It is in your paragraph, page number 7. Just now you read.
In response to the.
Second paragraph at page 7.
Yes, yes, Lordship. This is Lordship, just a second. 31/7/2015, Lordship, Annexer K. K.
Where is your annexer A here?
K. It's voluminous.
101.
Third of this is L.
By which communication you have forwarded to the Land Management Department for approval?
101, Lordship, this is.
Now see, 101, what was the estimate that you have prepared and forwarded?
With reference to the so that in the same way, I am directed to convey the approval of the estimate of the compensation of properties as reassessed by the press board.
Where is annexer K? Annexer K,
Annexer K is Lordship this,
page
71. Page 71, Lordship. Forwarding of comparative estimate in connection with construction of. This is the comparative, Lordship, this whole volume is.
So you have forwarded.
Yes.
Now on the right hand column, you have shown 100% Solium. It is there. Let us see page number 72, the right hand column. Serial number 14, page number 72. Have you seen? Have you seen
Serial number 14, Lordship?
Yes, serial number 14. In the box. Column number 14.
Yes, I am.
Column number 14 is the market value.
Yes.
Column number 18 is the Solium. Column number 19.
Yes.
Column number 19 is the Solium.
Mm-hmm.
Right?
Lordship.
then you have this value of,
Yes, Lordship, Solium 100%, Lordship.
you have assessed,
Yes,
and this was approved. This was approved by the Land Management Department at page 101.
yes, Lordship,
Right?
yes,
And you have assessed for all. Oral you have assessed.
for all the beneficiaries.
Fine. And you have paid this amount to the petitioners or yet to be paid.
That part, Lordship. I don't know.
Whether amount was paid or not.
Up to 359 we have paid, but then this amount we have paid or not, Lordship.
Then what is your affidavit? देखो, matter relates to payment of compensation for land to the landowners in the Balipara dash Charduar dash Tawang road. Chainage from kilometer km 1672 to kilometer 174 under Dirang Circle of West Kameng district of Arunachal Pradesh. Land of the landowners. The said portion of land was taken over under the provisions of Land Acquisition Act 1874. Amended in 1984. prior to the coming of the force of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013, in short LARR Act 2013. Award was passed. Compensation was also disbursed under the Land Acquisition Act 1894 in the year 2012. As there are anomalies in payment of such compensation, like payment of compensation for more land while acquiring lesser quantity of land, or payment of lesser compensation while acquiring more land. Writ petition was filed in the year 2012 by some of the affected landowners, being WPC number 154/2012.
153 and 154, two writ petitions.
153 and 154, 2012. Those writ petitions were disposed of by judgment and order dated 09/08/2012. Observing that the disposal by judgment. In the said judgment dated 09/08/2012, direction was issued to the Central Bureau of Investigation to make an inquiry into the matter and to find out the truth on the alleged irregularities committed by the members of the board of the Compensation Assessment Committee and other persons, including the local MLA. Allowing the CBI to take necessary action against the persons, officials found involved in commission of irregularities and fraud in accordance law. By the said judgment and order dated 09/08/2012, the court also directed the Chief Secretary of the State to constitute a new compensation board with the Deputy Commissioner of West Kamen District, Bomdila, as its chairman, and 3 other responsible officers of the rank of Deputy Secretary of the Department of Revenue, Agriculture, and PWD for correct assessment of valuation of the properties involved and submit fresh report before the authorities concerned within a specified time. Prior to, accordingly, a CBI inquiry was instituted with regard to disbursement of compensation for the said land noted above. And a board was also constituted by the Chief Secretary of the state for reassessment. Prior to this judgment in order is 0908/2012, as far as the assessment made by the Deputy Commissioner, the compensation, acquisition compensation board under the chairmanship of Deputy Commissioner Bomdila, the requiring authority, the Border Road Task Force paid the compensation amount amounting to rupees, you have said somewhere in the affidavit.
Crore 48 lakhs,
Hmm?
21 crore 48 lakhs, 82,533.
Where is it?
Page 3, madam.
Of the affidavit or
The affidavit filed by the government, ma'am.
which case? First case or second case?
The first case, madam. It may be.
Page 3, Lordship. Page 3.
No, in the other case, there are certain
Lordship, so far the petitioners are concerned, they have been paid excess, Lordship. And we have stated also that in our affidavit. Page 3, Lordship.
Page 3,
Second paragraph, madam. On March 13th.
in March 2012, on 31/03/2012 itself deposited an amount of rupees 21,48,82,539 for the Deputy Commissioner Bomdila for the construction of said road under the Rang Circle. Out of which rupees 20,65,83,018 was for KM 167 to 174. This was for three parts.
Yes,
What is the actual amount paid for this portion, 174? Because we are related to 174 to 183 only, not for others, I believe.
yes.
Only for 174 to
No,
183.
my lord, the first case, we are concerned with 167 to 174. In the first case, my lord. And in the next is 183 to 212, change.
First case relates to 167.
Yes, my lord, 167 to 1.
Just make it, change it.
71, 71.
Rupees 82, 99, 521. Was for
167.00 kilometer to 174.00 kilometers.
167 kilometer, km 167 to 174, comma, km 183 to 195, and 195 to 212. Whereas don't write whereas. Further, the BRO also deposited rupees, now this paragraph, 21 that you have read, it will come in the second paragraph. 167 to 174, 183 to 195, and 195 to 212. Prior to the CBI inquiry, compensation were paid to 359 beneficiaries, but after initiation of the CBI inquiry, compensation to the other beneficiaries, to the unpaid beneficiaries, if any, have not been paid. The Secretary Land Management, Government of Arunachal Pradesh, however, where is that letter directing you to reassess under the new act?
One 75 lawsuit.
75.
Mm.
Where is that letter by which you are asked to assess that?
Yes. Of WC 344, 75, page 75.
Which rate petition? 345 or 344?
My reply, 344,
344.
page 75.
It will be, my lord, I think 111, my lord.
Ah, that's right. That is fax copy.
Yes, my lord. 111 is the approval from the government, ma'am.
No, not.
111, my lord.
There's a fax message. Just now I will.
This is 2013.
On small short messages, there are fax messages.
In my affidavit, my lord, at page 47, my lord.
The Second Commissioner Land Management, Arunachal Pradesh, on 31/03/2015, directed the Deputy Commissioner Bomdila
This is appropriate.
What is WPC 325 FD? Page number 77 of the WPC number 344.
So it is when Lordship.
77 of the WPC number 344.
This is a fax message, Lordship.
What is that WPC number 325, madam?
It has not been annexed in my,
You should do it.
no, it is not annexed in my, oh, sir.
You should have called for it. You are the court officers. Unless you assist the court, how the final order can come out?
My lord, it is annexed.
Is this case status are available in the computer system?
My lord, this is a affidavit
Hold
filed
on.
by the government, my lord. They have not, they have,
What is the 325 AP?
my lord, they have not put it, my lord.
Whether the case status are available in the court system? Case status are available in the computer system? Madam, case status are 325. We don't know which year. The commissioner knows.
This is the affidavit filed by them, my lord. They have not annexed the documents in my, they have annexed it in the. court bureau.
325. Citizen's party's name is Dorji Khandu.
And others was a state of FD Lordship. Every year is okay.
Any party by Dorji Khandu 325. It should be around 2012, 13, 14, 15, somewhere like that. It should be 2013, 14. You just find out later. Who's 325? The Commissioner Land Management, Government of Arunachal Pradesh directed the Deputy Commissioner Bomdila to submit the compensation assessment with the rates, revised rates, enhanced rates for completion of payment of remaining compensation for construction of said BCT Trans Arunachal Highway Road under Dirang Circle of West Kameng District. Along with the differential cost with the previous rates as per Land Acquisition Act 1894. With the cost of that of the new act, that is LARR Act 2013. Request to furnish assessments essentials as admissible within the provisions of say 2013 Act. The newly constituted board headed by the Deputy Commissioner, West Coming District, on 31/07/2015, (31/7) or 31/8? Madam,
3/8, Lordship.
31st of August or 3rd August.
3rd August, Lordship.
On 3rd August 2015. No, not 3rd August. When did you submit the proposal again? Those are letters. On 31/07/2015, submitted the comparative estimate matter, comparative statement of land, the acquisition compensation before the land management, Commissioner Land Management, Government of Arunachal Pradesh.
31.
And the Secretary Land Management, by its notification dated 20, is it 26? Is it 26 August, last annexure? December or 3rd December? Where is the approval? Approval of the government. Yes, Madam Mita, where is the approval of the government?
Lordship, this is 3/8/2015 approval list.
How can we approve with CA 2015?
Yes.
We have submitted only in August 2015.
No, submission is, Lordship, July.
Where is the approval?
Approval is, Lordship, 3/8/2015 and submission is, Lordship, 31 July 2015.
Okay.
To the Commissioner Land Management. Lordship. Forwarding of comparative estimate.
But it has been issued by the director, not by the commissioner.
Yes, that is,
How can he do that?
yes,
Director is not the government.
yes.
How come director can give approval? Under which provision director is the government? Executive rules of business doesn't say that director is the government.
No,
Then either the secretary
Secretary.
or the commissioner or the joint secretary has been approved by the government.
Yes, Lordship.
Why the director is, where is the authority of the director to give approval? In this letter, there is no mention. There's approved by the
Lordship,
government.
here it says that I am directed to convey the approval of the estimate of the compensation for parties reassessed by the press board.
See, just right. On 03/08/2015, the Director of Land Management intimated the Deputy Commissioner, West Cameng District, Bomdila,
Conveying the approval of.
intimated about the approval of the estimate of the compensation amount reassessed by the newly constituted board as per the LARR Act 2013, directing to incorporate 2% administrative charges and 8% establishment charges on land value over and above the compensation assessed. It is to be noted herein, it is the Director of Land Management, Government of Arunachal Pradesh, who have indicated about the approval of the said assessment of land acquisition compensation and not by the Commissioner or Secretary of the Land Management Department of the state, who is empowered to represent the state. Why these kind of things are going on in the state of Arunachal Pradesh? When the money is somebody else, other departments, border roads or something, many things are coming out in different way. Sad to say. And look at the roads you are going, that state's money, nothing is coming. This is unfair. Now the petitioners in this petition, these petitions, are praying for a direction to release a compensation to them as per reassessment valuation report with 100% Solium as per the provisions of LARR Act 2013, though their land was acquired under the provisions of the what is that Zoom cultivation, right?
Balipara Tirap Sadia, Frontier Track, June Land Regulation Act 1947.
1947, no?
Yes,
Balipara, where is in volume 1 or 2?
page 47 of my affidavit.
57 of your read petition?
Yes, my lord.
Forty-seven of your affidavit or
Read petition, my lord.
which one?
The first one, my lord.
344.
3444.
On the right. Right. Though their land was acquired in the year 2012 and prior to that, under the provisions of Land Acquisition Act 1894 amended in 1984, for which compensation amount was already deposited by the BRO authorities. On the next date fixed, Commissioner of Secretary shall produce land or Commissioner Secretary Land Management Department shall place the records of file number LM-85 oblique 2012 oblique 1386 1212, wherein the Director of Land Management issued the communication number LM-85 oblique 2012 oblique 1386 dated 03/08/2015, Annexure L, WPC number 345 oblique 2019. List on.
My lord, may I please, my lord, one just small clarification, my lord. Apart from the fact that, my lord, even if it was acquired under the Balifara Act, my lord, the 1947 Act, my lord, but here, my lord, after the reassessment, my lord, it was assessed under the new Act, my lord. But then, my lord, my grievance is that, my lord,
Yes.
my grievance is that, my lord, similarly situated persons, my lord, who received compensation, my lord, they were after the reassessment, they were given 100% Solium, my lord.
Just continue.
But
It
we
is
were not
placed by the petitioners that similarly situated persons have already been paid compensation for the said rate at 100% Solium under the LAR Act 2013. Though land was acquired prior to 2012 and compensation was assessed in their LA Act 1894.
No, my lord. No, my lord. They were paid compensation along with us, my lord, in 2012, my lord. 30%, my lord. After the reassessment, my lord, new assessment was done under the 2013 Act, my lord.
List on.
Only that part, my lord.
Wednesday, 26th. Copy of this order be furnished to. What's your good name? Ask him to appear on Monday before this court.
Your Lordship, the
No
standing
further-
counsel is out of station, will be out of station.
Whatever, ask him wherever he is. Court is asking him to here. He may be somewhere else. He should be here.
When is
There's
it,
the
my lord?
direction to Mr. Kamduk to be here. Otherwise, the Commissioner Secretary has to remain personally present. Failing on the part of the Commissioner Secretary, Land Management Department, to place the relevant record as directed above on such and such date. He has to personally remain present before this court on 25th, 26th.
26. Oblige, my lord.
Don't play with the court. Ask your counsel whoever who do not know.
Item number 5.
My lord, in item number 5, the state respondents have filed their affidavit.
Yes,
I have not filed my rejoinder, my lord. I may be given an opportunity to file the rejoinder.
when such affidavit was filed,
It was filed on, my lord, 5/5/2022.
5/5/2022. And we are in which year?
24, my lord,
Which month?
June.
When will you file your rejoinder?
I have not filed.
That you have seen. When will you file your rejoinder?
My lord, it may be listed immediately after the summer break. In the meantime, I will file.
Lordship, this may be listed next week, Lordship, because they have been asking for time continuously. That's why this was dismissed for default also once. Even then, they are still, Lordship, we have filed our reply in 2020 itself, Lordship. This is 2020 matter. And this is with regard to the encroachment in the Lordship airfield, Lordship, at Pasigat.
What is their prayer here? In the writ petition?
Okay. So it got a advanced landing ground Lordship notification within 100 meter. The trees, height, any kind of building is not allowed. Lordship.
Everywhere.
I have an extra notification also, Lordship. Lordship. And just after taking a note, simple note, he asked for the.
Now, what is the status? Whether he has constructed a building or it has not been
Yes,
constructed?
yes, that's why they have the.
And now,
The
have you,
Air Force, they have complained, Lordship.
have you executed that order?
Lordship.
There is no stay order.
Stay order was there, but then recently, because they were taking time again and again, Lordship, they have.
See, sometimes you should know what to do.
It has been done away, Lordship,
You should know what to do.
because of my Lordship. But then, when, since it is pending before the Lordship, Honorable Court.
What I mentioned, there is no interim order.
Yes,
Then. And there is no interim order since beginning.
but then they have built the building already, Lordship, that's right. For the safety measures, Lordship. Of the flying aircrafts, Lordship. It has to be, they have to be habitat, Lordship.
From 26th of April 2021, there is no stay order. If you have not executed, not executed. It was last extended on 8/4/2021. The matter was listed after 26/4, and since 26/4, no stay order.
It is there, Lordship.
Up to you. We'll give 1 year period to the petitioner to file, to execute the order. If there are any unauthorized construction, break it.
The airports authority have lodged FIR also, and they have.
That is the reason,
given
madam.
Representation to the.
You should do it.
Deputy Commissioner.
You should do it. It is your action. No stay order. Court categorically mentioned that there is no stay order.
Yes, that is there, but then.
The court, after the court by order dated 8/4/2021 extended the interim order passed on 20/11/2020 to the next date of listing of the matter. Since 26/04/2021, there is the interim order is not in force in favor of the petitioner. The petition was earlier dismissed for non-prosecution, which was later restored on 16/6/2022. The respondent authorities filed their affidavit in the matter on 02/05/2022. Since then, the petitioner is taking time to file a rejoinder. Even today, the court, even today, the petitioner prayed for time to file rejoinder. The court categorically in its order 30-01-2024 observed that there is no stay order in force in the present petition. Subject to the payment of cost of rupees 10,000. Okay, we'll deduct it 5,000. Petition with the Secretary, State Legal Services Authority, Arunachal Pradesh. Petitioner may file her rejoinder, if any, on or before 19th of July. Needless to say, it is up to the respondent authorities to take appropriate action in accordance with law. With regard to any unauthorized action on the part of the petition side of the land involved in this case. Next.
Much of it.
Item number 8.
Lordship, this is wildlife sanctuary matter. Lordship. Lordship, here my Lordship. Submission is that Lordship.
See, we don't know why are you not taking any actions. See, even in Kaziranga, if we have gone through that route, there was lots of unauthorized entry of various persons, indigenous, non-indigenous, many persons. Long back, the division bench of our court passed an order for eviction of such unauthorized construction. Some of the political parties would deem allowing these people to be in the Kaziranga. So used to see more people in the Kaziranga reserve forest than the wildlife. Ultimately, division bench passed an order. The government, after contempt, have evicted all those persons. Now that is the seriousness of the government.
Lordship, yeah, I agree that Lordship.
Now up
because
to you.
here they have constructed the quarter of 4, 5, 4, 3, type 4, type 3, type 2, Lordship, and a barrack. And in that place they have constructed their Lordship.
No, if it is in the wildlife.
In the wildlife sanctuary, Lordship.
And it may be only if the forest department be allowed, nobody else. If
Lordship,
the petitioner is occupying, you should do the needful.
in a similar matter, Lordship, here in this court itself, Lordship, there is a judgment. Lordship. They were also engrossers saying that.
That is why we are asking you, there has to be a notification in the gazette that this particular area is within the reserve forest land.
Lordship, notification, reserve forest notification is here, Lordship.
Give it to us. This particular land falls under that particular.
Yes, this very particular has been converted to sanctuary, Lordship, since they sanctuary, they have higher protection, Lordship, in sanctuary, Lordship. As per section 26B, Lordship. As per Wildlife Protection Act, Lordship. This has been. Here, they are not only encroachers, they have lordship, destroyed the property of the government also, lordship, wildlife sanctuary. They have set on fire, lordship, we have stated in our affidavit. 4 government quarters. And because
Have you
this-
notified?
this matter have a status quo, lordship, after getting status quo, they are building their construction. Construction is going on,
Now
lordship.
just tell us, where you have mentioned that the area occupied by the petitioners are within this land.
Lordship. Lordship may come to my affidavit. By respondent number 2.
Yes, where it is mentioned.
Lordship, para 6. Page 3.
Para 6, page 3.
Yes, Lordship. State government has notified Itanagar Reserve Forest and Wildlife Sanctuary by notification so and so, Lordship so and so. Notifications and map of Itanagar showing the location of lobby, place of occurrence, Lordship. That before notification, all rights and claims were settled for
Now,
following
the land
villages.
involved in this petition is within which area?
Lobby, Lordship. This is Lordship, para 6, paragraph 6, showing the location of lobby, place of occurrence, Lordship,
Para 6.
para 6. We are saying this as place of occurrence because in para,
Notification and map of Itanagar showing the location of lobby,
Mm.
place of occurrence.
Lordship, we have annexed the map also. And then because
So
this-
petitioner's
this-
land is not excluded.
they are full encroachers, Lordship, because this name of the, in the next page, name of the excluded area, Lordship. These are the only excluded area.
Now, where from you are
Tarajoli
saying,
village.
where from you are saying that the petitioners are in occupation of the reserve forest land? You have any map, digital map or anything, satellite map?
Satellite map, Lordship. We have annexed, Lordship.
Where is it?
Even the photographs we have given, Lordship.
No. Satellite map to show that they are inside the forest land, reserve forest land. Where will you get it?
Lordship.
It has to be within the reserve forest land, no? Where is it?
Lordship, may kindly come to page 5.
Yes, 5, yes.
Mhm.
Yes.
Lordship, here the encroachers, petitioners were staying at lobby forest colony since so and so. They were unauthorized staying in the government buildings, forest departments. They did not obtain any allotment permission. They are not in the office also, Lordship. They had forcibly occupied government building. They were repeatedly asked to vacate the building and were served notice also, but the petitioners did not comply the same. And then, Lordship, their name in the against which they were against which quarter they were staying is shown here, Lordship.
Yes. Who is for the petition?
And then, Lordship, may
Who is for
also
the petition?
My lord, my humble apology. The council, senior council, he is not available today.
Doesn't matter. Your senior counsel, junior counsel, enforcers are always enforcers. Right?
I'm not aware about the facts, my lord.
Hmm?
Hearing may be taken up in his presence, my lord.
when quarters were burned down, Lordship, it was reported also they were arrested also, Lordship. Notices were given, Lordship. We have annexed everything, Lordship. And Lordship, at page 135, Lordship, we have given the sanction order by which these quarters were being built, Lordship.
A recent judgment is there of Justice Devasis Burua. You'll get it in the uploaded version. Now, sitting in a division bench, we have also passed an order.
Lordship,
This
the
was
one-
as a reserve forest land.
Yeah.
In the heart of the city of Guwahati. That was occupied by many. Now, in that case, Municipal Corporation of the Guwahati have also assessed that area. In spite of being a forest land. There are schools, there are temples, there is mosques, there are other offices. So there was a chaos. Ultimately, the learned single judge, Brother Justice Burua, have considered all aspects of the matter and clarified, even if it comes under the municipal corporation, it was wrongly incorporated because they had no such right once that notification was published in the Gazette that it's a forest land. It's available in the website. Find it out. Because in the reply, they have said that it comes under the municipal area.
Yes. Lordship, may kindly see page 148 map of this wildlife
No.
area, and then the one 35 page
They have
35
said
also.
in their reply
Yes,
that it is in the municipal area because some
148, Lordship, page 148.
it comes under ward number 8 of Itanagar municipality.
No, recently they have done that, Lordship. This is,
That is what we are saying, because the notification is of 1978, right?
Lordship.
April 1978.
Yes,
1978, there was no municipal publicity
no, Lordship.
in the Itanagar. So they have made it ward number 8 and they are incorporated ward number 8. So in Guwahati also same thing had happened. That reserve forest was within the city of Guwahati. So Justice Burua has passed an order which has been upheld by the division bench.
Lordship,
Myself, which I forgot who it is, Justice
Lordship,
Mithali
if
Thakur.
not today, Lordship, can this matter be taken up next week to dispose, Lordship? Because under the garb of status quo, they are building the construction is going on.
That is up to you to bring it to the notice of the court.
Yes, Lordship. No, Lordship, we have filed contempt also against that, but then the matter never came up again.
Why contempt? Why did not you fasten a miscase? They are
Lordship,
violating the order.
many a times I have brought it before the Lordship, but then
Nothing will happen in that.
would not.
Take out that order of Justice Devasis Burua. That
Lordship,
will help you.
Lordship.
Already there is an order of Justice Surana. So we can take the recourse of that.
I have given one, Lordship. There is.
That is it.
That, Lordship.
We have seen.
Lordship.
Now no point. So already time is over. Yesterday that criminal matter, that what we will see.
Lordship, when this is.
All will come after vacation.
Lordship.
Registry will give the dates.
Yes, my lord, may I please, my lord? My lord, item number 22, there is interim order, my lord. Item number 22, my lord. There is interim order.
If there is an interim order, that will be in force. Nothing to worry.
My lord.
Item.
That criminal appeal.
Item number 10. Item number 10.
Yes. Lordship, so far, Deputy Commissioner's order, Lordship, I don't see any infirmity here, Lordship, since the documents, Lordship, the sale deed and the gift deed is in the name of the respondent, Lordship.
List on Tuesday. We'll pass the order. Keep this in Tuesday. Remaining matters as per the registry, they will fix it.